Good morning. Welcome to today's Planning Commission meeting. Today is March 27th, 2025, and I call the meeting to order at 9 a.m. Can we please stand for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Can we get verification of legal notice?
Yes, Mr. Chair, all items have been legally noticed.
Thank you. And we have one item on the consent agenda, which is to approve the minutes from February 27th, 2025, Planning Commission meeting.
So moved.
Second.
We got a motion and a second. All in favor? Aye.
Aye.
All opposed? Seeing that we all say motion passes. Moving on, we have a little bit of time before our 9:05 item. So we will take public input on any item that is not in today's Planning Commission hearing. Any person may speak for 3 minutes about any subject of concern, provided that it is within the jurisdiction of the Planning Commission and is not already on today's agenda or scheduled for a future public hearing. Speakers are requested to legibly write your name on the sign-in sheet at the podium and state your first and last name for the record.
Good morning. My name is Tom Lasik. It's not directly related to what's going on here, but I just wanted to point out, maybe as a process improvement, the Granicus website, for some reason, doesn't allow the public to upload documents. I discussed this with Joanna DeLong earlier this week. She's able to do it, but I think she has admin privileges. But I think it would make things go a lot smoother if the public had the ability to upload comments that were longer than what the Granicus text box allows. I think it would also make it life easier for staff. It came up today in this hearing because I did you're forced to send it in, and it got lost. So fortunately, they found it, but I think it would be better if Granicus was improved to make that easier for the public. Thank you.
Thank you for your comment. If anybody else wishes to come up, we'll check the Zoom room. I'm not sure if there's a hand there. We'll take a look in a second. All right.
Sorry. No one's got their hands up.
All right. There's no hands in the Zoom room.
No, Mr. Chair. Oh,
All right. We see one hand there in the Zoom room. We'll unmute, and you have 3 minutes. And please state your first and last name.
Donna Makowitz. This may not be needed. I didn't need a passcode to sign in, but I guess sometimes you don't require one. Thank you.
Hi, Donna, was it? Can you repeat your comment? I think we might have missed the first part that you said.
It may not be important, but a passcode was not required to log into this meeting.
Oh, okay. Thank you. All right, looks like we have about another minute till we take on our first item at 9:05.
May I go ahead and speak?
Yes. Just,
My name is Joni Henderson. I did just want to follow up on what Tom Lushik was saying. I didn't realize that, but there was another issue with public comments not being attached or included in public comments. This is not the first time, and it is putting the public at a disadvantage able to submit their comments into this process. So I did just want to bring that to light. This is happening. It's happened with others. I know for a fact it's happened with this situation that I'm involved in, with pretty important documentation has not been included in the documentation. So I do want to ask that you please look into that so that it is a fair process and unbiased. Thank you. Do I need to sign in here for commenting?
Could you state your first and last name one more
Yes,
time?
Joni Henderson.
Thank you, Joni. And seeing that it is 9:05, we'll take on our first item, consideration of proposed major use permit, UP 21-07, Little High Valley at 17870, Little High Valley LLC, and mitigated negative declaration IS 21-07 for the approval of 2 A-type 3 outdoor commercial cannabis cultivation licenses and 1 type 13 self-distribution transport only license at 17870 Little High Valley Road in Lower Lake. The APN number is 012-061-03. And staff.
Good morning, Commissioners. This one. Mic check, mic check. Okay. Good morning, Commissioners. Mary Claiborne, Senior Planner with the Community Development Department. At the time of preparing the materials for today's hearing, the staff report did recommend denial of the project based on recent court rulings serving as case precedent. However, on March 20th, 2025, the Department of Cannabis Control announced that the Supreme Court has depublished the California Court of Appeal decision in J.C. Crandall versus County of Santa Barbara, rendering this ineffective as precedent. Consequently, staff is now recommending approval of the project as it meets the findings required for major use permit approval. The Planning Commission has indicated that a continuance of the project to today, March 27, 2025, is the final extension they are willing to offer. Staff recommends that the Planning Commission review the previously submitted staff report dated February 13, 2025 concerning this project or continue the project. The project consultant and the farm manager are present in chambers and have prepared a presentation for the commission. Today for your consideration is UP 21-07, IS 21-07, Little High Valley at 17870 Little High Valley Road in Lower Lake. On February 13th, this item was brought before the Planning Commission, having been continued from the December 12th hearing, which was also continued from the initial hearing date of October 10th, 2024. During the hearing, public comments were introduced to the administrative record, which provided new information relevant to case law. A continuation of the project was scheduled to a date and time certain to allow the applicant an opportunity to consult with their counsel. The project scope consists of 87,120 square feet, which is 2 acres of outdoor commercial cannabis canopy, a proposed 3,500 square foot metal building for cannabis processing, equipped with permanent accessible restroom facility, 4 2,500 gallon water storage tanks for irrigation, and a metal water storage tank equipped with a 2.5-inch quick coupling for use by the fire districts for fire suppression needs. There's also a proposed employee parking area with 8 spaces, included 1 dedicated to ADA accessibility. Again, at the time of preparing the materials for today's meeting, the staff report recommended denial of the project based on recent court rulings serving as case precedent. The Supreme Court has since depublished the California Court of Appeals decision in J.C. Crandall versus County of Santa Barbara, rendering it ineffective as precedent, and staff is recommending approval of the project as the project does meet the findings required for major use permit approval, as previously noted with staff's reports from October 10th, 2024, December 12th, 2024, and February 13th, 2025. The recommendations for this project are, for consideration, are potentially a continuation of the project or to adopt the Mitigated Negative Declaration Initial Study IS 2107 for Use Permit 2107 with findings found in the staff report dated February 13th, 2025. Major use permit recommendations are to approve use permit 2107 with the proposed conditions of approval with the findings found in the staff report dated February 13th, 2025. And I'm available for any questions or any comments that you may have. Thank you.
Thank you. Is there any questions from the commission?
Excuse me, I have a question on the just clarification of what depublishing is. Does that mean it was overturned or just depublished? And that was the California Supreme Court, not the U.S. Supreme Court, is that correct? And so, so in my many years of law school and Google, it said that if it's depublished or if something is depublished, it still can be used in certain instances to be cited if it's not a legal proceedings. So I just sort of looking for some clarification if it can be used and what's the difference between depublishing and being overturned.
Overruled, yeah. Commissioners, if I may. So you are correct. It was the California Supreme Court that made the decision to depublish this ruling. And it was at the request of the California Department of Cannabis Control. And there was a review period between the last meeting and this one of your commission for this item. And the Supreme Court's depublication does not provide reasons, and it doesn't provide any kind of ruling, which means that the Supreme Court did not clear up the issues. They didn't give an opinion either way as to the legal arguments in the decision. The decision itself still applies to the parties that were involved in that case, but it is not legally binding throughout the state of California.
Well, you're saying it's not a precedent?
Correct. So it cannot be cited, and it cannot be relied upon as governing authority for the interpretation of those rules that apply in that instance. So it is not something that your commission would be required to apply in this instance. It wouldn't govern your decision.
So not required, but could be? Just trying to understand. It sounds like we're sort of threading a needle here.
No, you're correct. There are circumstances in which a depublished decision may be relied upon. However, this is not one of them. There are very narrow circumstances and very narrow scopes in which the law provides exceptions, but those don't apply here for your decision. So the ruling would not be applicable to your decision today.
Thank you.
I have a question, just for clarification with council. For site visits, when do I report? When is it appropriate for me to report?
When there's a discussion, when discussion is brought to the commission, it's as a whole for the item. So whenever the chair has potentially, whenever the chair has brought it back for discussion at the, right, so typically in the past that I think has been after the public comment period.
Okay, thank you. And then for county staff, I have a question on the building, on the metal building. Could you explain a little bit more about that? Does that building have power? Just some specifics.
Yes, so a metal building for processing, for cannabis processing, is for the hanging, drying, trimming, curing of cannabis product. And with that, it would require to have electrical needs. That would include lighting, adequate lighting, fans, dehumidifiers, or air conditioners to keep the climate control for the cannabis processing portion of the project.
So then that does require a building permit?
Absolutely.
Okay.
Absolutely, it does.
Okay, thank you.
Are there any more questions?
Yes. First of all, there's a question about the homeschool, what constitutes a school. And my understanding is that it's anything that is a gathering place for children. Can somebody clarify that for me?
Commissioners, I can help with that. So in the California Code that applies to this particular type of decision, there is a definition for cannabis products and their distribution and measuring setbacks from the, not just distribution, but cultivation. And under state law, it's 600 feet. However, for rules such as this, local municipalities can adopt as strict or stricter rules, and for this county, it's 1,000 feet. So under our ordinance. However, the definition of school is under both the state law and under our ordinance for cannabis cultivation purposes is as follows. School means any public or private school providing instruction in kindergarten or any of grades 1 to 12 inclusive, but does not include any private school in which education is primarily conducted in a private home.
Thank you, that answers my question. We also have in front of us two rather lengthy comments from Thomas Lachik. And I think they bring up some relevant questions. The easement, is the easement adequate? There's an argument being made that it's not wide enough. The proposed road is not wide enough to meet California fire codes.
I can respond to this question. Historically, we have applied 4290, 4291 requirements to project parcels themselves for interior roadway improvements. I did speak with Assistant Fire Chief Wink yesterday, and he advised that while we have done that, it's kind of a gray area, and this is something that I'd like to follow up with him on for an official public comment or agency comment for the record. But he advised that in circumstances such as these with a project like Little High Valley utilizing easements, that driveway standards would be applied to 4290, 4291 requirements and not the roadway itself requirements. But I do not have that in writing from the Assistant Fire Chief.
And I believe sorry to interrupt, I believe we've had another project in the past where it was like the same case. We had the road going up to that property.
Chair Chavez,
it was-
may I request a 5-minute recess, please?
Sure.
Thank you.
So we'll take a 5-minute break we'll come back at 9:23. All right, welcome back. I am showing a time of 9:23. I hope that was enough time for staff to
Yes, thank
clear
you.
out those questions. All right, perfect. With that being said, do you guys have any comments?
Yes, we do have additional information to add regarding road improvements.
Commissioners, so 4290 and 4291 oftentimes can be confusing, so I thought I'd provide a little bit of a clarification. 4290 and 4291 are just sort of a general reference to a pair of code sections that direct two state departments to come up with minimum fire safety standards. The code sections themselves do not actually contain those standards. Those standards are actually put in the California Code of Regulations, and they're not just the minimum fire safety standards, but there are general fire safety standards there as well. And the minimum fire safety standards do require the improvement of roads to a particular standard for fire safety. right? Access, the ability to handle firefighting apparatuses and that sort of thing. So turnouts, as I'm sure you've heard, and road sort of surface improvements. How they apply to a specific project would be something that you would communicate with or you'd receive the information from staff. But as far as generally applying, with road improvements, the general fire code rules do in fact, under Division 19, do in fact require that roads be improved to the nearest, from the project site to the nearest public road. However, there is the ability to apply for an exception if that is impractical for the area, and the exception is not that those requirements are waived. The exception is that that the individual applicant and the local municipality can determine equivalent standards that are different. They would have the same practical effect of the code requirements, but they would be tailored for the specific roadway that is in question. To do that, to apply for an exception, an applicant would need to do so in writing to the agency that handles inspections, and there are criteria as to what they would have to provide. It's very similar to a variance request where they would have to share what the conditions are of their property. They would have to provide a description of what they think, what the issue is, as to why the standard minimum fire safe regulations wouldn't work, and they would work with the local jurisdiction to find a practical equivalent that would work. In this case, that would potentially be applicable here if under Section 5.03 that requires that the road be improved in the general, I think it's Division 19 of the CCNRs for California, Section 5.03, if the road is required to be improved from the property site all the way to the next public access road, then to not be required to do that up to the road standards with 2 lanes of 10 feet each and all of the turnouts that may be required and what have you, that exception would have to be applied for. So in this case, I would think that if your concern is that it doesn't meet, if your commission's concern is that this project doesn't meet the road safety standards under the 4290, 4291 requirements, then you have the option of considering continuing the item and allowing the applicant to apply for an exception so that they can find an equivalent, practical equivalent standard that would work for this project.
Thank you, Nicole. I'm very concerned about, I know how wide 14 feet is. It's not very big. I'm very concerned about this. I want to protect the safety of our firefighters. It's very likely, I looked at the satellite photos of this, there's going to be a fire there at some point. But I also have another, if we can move on to the issue of the homeschool again, or do you want to keep talking about the road?
If we could keep it on the road for
Okay.
now, since we're talking about it, and then we can go back to that one later. I did have, or if you wanted to continue on, if you had any more.
No, just that I feel that we should either continue this for that reason. There's some other reasons, there are other issues as well, but I want to hear what other people think about the road issue.
I have concerns about the road as well, so I was going to wait till after public comment to discuss that, but it's here now. So, yes, I do have concerns about the road as well. So, should I go into depth in those, or?
I haven't been to the location physically, and I believe you have, so I'd like to hear what you saw, if that's okay with Nicole.
Yes. So in that regard, then I'm going to go ahead and.
The order of the meeting is governed largely by the chair. So if the chair is opening for discussion, then certainly.
We can open for discussion before we take it to public input. That's fine.
Okay, in which case then I'm going to go ahead and share with with my fellow commissioners that I did do a site visit at this location. I also want to state that in preparation for this, given as the staff report says that this hearing has been continued a number of different times, I did watch the recordings for both the December and February Planning Commission meetings related to this project. I also had a conversation with Mike Wink, chief of, he covers several areas now, Napa, Lake, Mendocino, I believe. Anyway, but I did have a brief discussion with him in regard to this project as well. Site visits, on Sunday, March 23rd, I met with the neighbors there at near Little High Valley, near this project. We reviewed many of the items that were previously discussed in the previous hearings for this project, including the private road and the condition of that road, the easements, controlled burn that was done on the property at another time, the setback from a home school, water use, power source, and the grading issue that was addressed at one of the previous meetings. I also met on Monday, March 24th, with Travis Lisenby, the project manager, and we walked the project site from the gate on up to the water tanks in the hill. He showed me where the grow site was, or planned to be, proposed to be, the location of the well, the location of the one shipping container that's on the property that, as I understand it, is permitted. So let's see, we also talked with both parties. We talked about the recent court ruling and the overturning of that ruling. In regard to the road, I drove the road. So the Little High Valley connects off of Spruce Grove. I observed several spots on the private road where maintenance has been done. I also observed narrow sections, washed out sections, potholes that had been filled, gravel layer on the steep slope, which that slope does appear to be somewhere in the realm of 30% or so, that slope. There are water berms that have been put into the road, so there apparently is water that washes across the road at different times of the year. Areas where it was apparent, that water will drain on the road. So with that, yes, I do have concerns about the road access and the safety of getting equipment up and down, but also the safety of the people that reside in the area. So, and I welcome any questions as well.
Yeah, thank you for explaining your trip down there and giving us a little bit of a perspective, I guess, on the road conditions. I think it's important to sometimes go out there and take a drive and kind of see what it's like and to getting to the project site. So I think it's a good idea to do that every once in a while.
So thank you for thank you for your due diligence on that and your information. On the road, if it were to be improved, would there have to be permission from all the landowners from the county road to the destination in order to do that improvement?
There are easements that are deeded, and maintenance is part of those easement agreements.
Does that allow for widening of the road?
It potentially can. Some of the easements are listed as up to 60 feet wide. However, they're not that big at all. There could be potentially widening. That would trigger a grading permit, and that's not something that is considered. At this time, it was just maintenance of the existing road that has been conducted at the site.
So if it had to be improved, there would have to be some other criteria or steps in order to do that?
Yes, should they decide to widen the road, then a complex grading permit likely would need to be applied for with a CEQA analysis for that widening.
Thank you.
One quick question. So basically the options that we have are either continue the item to allow the applicant to see if they can get some sort of variance on the improvements of the road, or taking this item as it is presented today, with the questions about road improvements. or failure to, I mean, if we have concerns about how the road is currently, is that correct?
Yes, Commissioner. The decisions presented to you today are accept the application, as always, accept the application as presented, as staff has presented in its entirety, accept it with changes or deny. And in this case, my understanding is there is a condition in the permit conditions which requires that the applicant meet all 4290 and 4291 standards. If you move forward with this approval now, and it turns out that very strict 4290, 4291 standards are applicable here, and that the applicant cannot do it, it either puts them in a position of the permit never becoming valid, and or them violating their permit and being subject to revocation.
I have a
Again, following my site visit with everyone involved in this project at this point, both the neighbors and the applicant, I think there's a lack of clarification of exactly what is needed to comply with 4290, 4291. So that is my concern. Is there were several spots in the road that turning radius, turnaround at the end of the road, that one steep slope that is in the roadway, and also, supplying a couple of pull-out, areas, for safe travel in those areas that perhaps can't be widened because of just because of the area. But I think, that there could be, equivalent road conditions that are created, that would allow for, space for two vehicles to pass and for large fire equipment or, safety equipment to get up and down that road safely. So anyway, those are my comments there.
My biggest concern is the width, but 30% grade is pretty steep. I don't know enough about fire trucks and what they're capable of doing or not doing. If I can go over to the issue of the homeschool again. I'd just like to know how far it is from the project. I know that whether the easement is, or the setback is 600 or 1,000 feet. I don't know where this place is. So without divulging private information, can we know that?
Sure. So the minimum requirement for off-site residences to the cultivation site is 200 feet, and currently the off-site residence in question is 400 feet.
So thank you. It's well within the setback.
And that was just for residences, right?
Well, what I'm understanding is that there's a homeschool, and is that homeschool within 400 feet or within 600 feet?
Well, I think with the advice we got from council, or the clarification that we got was that private homes do not fall within the homeschool category.
Correct.
I understand that, but out of respect for the individual who requested this, I'd just like to know.
Commissioners, if you are in fact, so if the rule that requiring certain setbacks for schooling does not apply, in this case it does not, for a homeschool. However, to approve a permit, your commission needs to make several findings. And if you are disagreeing with how those findings are recommended to be made by staff, I would ask that you list the facts specific to this project that you find that lead you to not be able to find make those findings, right? And then make a recommendation for the Planning Commission as a whole as to how to amend the conditions or the permit in order to allow you to make those findings. If you're making a finding that a setback is required when it otherwise is not, as it would be in this instance, if you're looking at increasing the setback, I would ask that you provide the facts and circumstances that would support such a deviation. So solely because that analysis is not within the report as presented, and we would need to have that information on the record for the decision.
Okay, so my understanding is that a homeschool is a place where children gather. That's my interpretation. Am I incorrect in that?
We don't have a definition for homeschool in relation to cannabis cultivation. We do have a definition for what a school is for the setback to apply. And that definition, both under the state law and the county law, the county ordinance for cannabis cultivation, specifically excludes, here I'll give you the exact language. For the purposes of this section, or for cannabis cultivation, school means any public or private school providing instruction in kindergarten or any of grades 1 to 12 inclusive, but does not include any private school in which education is primarily conducted in private homes.
I remember another project near Kelseyville where I have this idea lodged in my head that it's any place where children gather. No, is that incorrect?
No,
Okay.
there may be other non-applicable rules, but you can certainly, or other standards that might have that in the definition, and staff could probably be a
That
better
would be a
help.
church. Yeah, church is
Yeah,
a place
that's a
where.
church, but-
Yeah, not a school.
But it's a place where children gather, isn't that the issue?
I think in that instance, it was a list of locations with certain kinds of services or functions, but not just, for example, not just a church in that case for services, but a church that provided some sort of service that was dedicated to children. So not just. So that those definitions wouldn't have applied to just a church. It would have applied to a church that had gatherings for children. I think the goal in those particular ordinances was to provide a setback for those locations where children gather, but I don't recall private homes being included in those.
Okay, so for me, the issue is whether children are at risk or not. And if children are gathering, whether it's a private home or a church or a park, it's a risk. So that's my interpretation.
Well, I think like council stated earlier, obviously it is, important to look into that as well. But the finding that you make can't be based on a private home being a homeschool.
Okay.
As tough as it, as it
Okay,
sounds.
so it has to do with,
I think the best way the only one that we're really dealing with right now, the current or the most important thing, I mean, that's important as well, but what we were just discussing about the road, the 4290 and 4291, to either tell the applicant or see if the applicant is willing to take the chance to apply for that variance, or we just make a vote today as we are right now. And then if the findings come back that those road improvements have to be made, and if the applicant is willing to make those road improvements, and that could potentially lead to whatever comes next.
Yes. So I agree. And in regard to the road improvements, I think it's, again, there needs to be clarification for the applicant and the neighbors of exactly what road improvements need to be made to the road that would be compliant, or at least closer to being compliant with 4290, and whether, the applicant is willing to do those improvements and/or, apply for the exception. So, which I'm not sure what the timeframe of that application process is and what's all involved. But again, I think that those are our options. But either way, it seems like either we're opening this up for public discussion so we can find out more, or that we are continuing this so that we can find out more. That's my
I'd like to
opinion.
request that we open the public comment
Yeah.
at this point.
Okay, seeing as that we already discussed this project quite a bit over here on this side, I'll be opening up public input. So anybody that wishes to speak, come up to the podium, state your first and last name, and we'll have 3 minutes, seeing that we have quite a bit of people. We're going to stick pretty strict to that 3 minutes. Oh yeah, if you wanted to do the presentation, I guess we'll allow that.
Yeah, thank you. Thank you, and I believe my presentation will address a lot of the concerns on the road.
State your first and last name.
I'm
for the
sorry.
record.
My name is Trey Sherrill, and I'm consultant for the applicant. So the purpose of my presentation was kind of, how many months are we on now? Like the 6th month of trying to, coming back and forth. And so just kind of going back, showing how we got here, and some of the issues that are raised every time we're in front of the Planning Commission, and just provide, some documents and things to address those. So yes, this is the project site. That's the proposed cultivation area. If we could go, thank you. So yeah, the first, no, that's okay, go ahead. Yeah, thank you. Yeah, so the first hearing was on October 10th. Neighbors particularly raised a lot of concerns specific to, water resources, roadway improvements, pesticides and security. So the commission requested a continuance on that time, and we had a site visit on November 8th. Following one of the concerns that were raised were a neighbor claims that their well was not considered in the hydrology study prepared for this project. And I just want to note that, and we've provided proof of this, county staff, that Realm Engineering, who prepared the hydrology study, questioned twice the California Department of Water Resources and the Lake County Environmental Health Department, trying to find out any information they could on the neighboring well. And there is no record that those two agencies have, and as far as I'm aware, no other agency has any record as well. Through county, well, we tried to, during the November 8th site visit, and then through email correspondence through county staff, we tried to reach out to the neighbor just to provide us any information on her well, so that we could, we even offered to pay, we would have a licensed professional service her well, so that if we ran a test on it, the well would be better after we were done running that test, and it is in its current condition. No response was ever received, and during the site visit, I was informed that she did not want to talk about the well at all. And so that was it. We had the hearing on December 12th. On December 12th, that hearing was continued due to concerns that were raised about possible grading violations. I'll discuss that on the next slide. But also on December 12th, the owner of a different neighboring parcel informed us that the well that provides water to the neighboring residents is actually on his property. And so I immediately emailed him a copy. He asked for a copy of the hydrology study. I emailed it to him. To date, we've seen him a couple times, and he has never expressed any concerns to me about any impacts from this project to his well. And ultimately, we don't know if the well is on his property or her property. We don't know where it's at. We know nothing about the well. We just are told that it is there. Could I have the next slide, please? So without knowing any information about the neighboring well, the best we can do is just how much water is potentially available to both wells. And so this is from the hydrology report that was produced for this project. They estimate that on normal years, 21.6 acre feet infiltrates into the groundwater.
How many gallons is that?
I'd have to run a conversion, but it's like, it's over 300,000 gallons per acre foot. So I can't do that math in my head. Yeah, sorry. Yeah. And then under severe drought conditions, this is based on like the lowest water year on record. They estimate that 6.3 acre feet would infiltrate into the aquifer below. And then at the bottom is the estimated annual water usage for proposed cultivation. During normal years would be 4.2 to 5.8 acre feet. That's, the variance there is based on different cultivation methods and different irrigation systems. And then per the drought management plan, there would be a 10% reduction in cultivation and canopy area. So therefore, water usage would be reduced by 10%, so down to 3.8 and to 5.2 acre feet per year. Next slide, please. And then so to estimate how much water the neighboring residents would require, I used the water supply and use conservation assessment guidelines from Permit Sonoma that estimates that a primary dwelling with an unspecified amount of landscaping will use approximately a half an acre foot per year. And then we apply that half acre, we add that a half acre foot, and it is still, even, so under normal conditions, where 21.6 acre feet of water is getting into the aquifer, it's more than 3 times the amount of water that would be used by both the project well and the neighboring well. And then under drought years, it is still more, even in drought years, there's still more water getting into the aquifer than the 2 wells would be using. And I also want to note that this is not considering that the 2 properties, so this is an 80 acre parcel, or the project parcel is. The neighboring parcel that has the residence is 80 acres, and then the other parcel that where the neighbor informed us that the well is on his property is 40 acres. So we're just, when we're talking about groundwater recharge, we're just considering the 80 acres of the project parcel, not the neighbor's parcels as well. So that number would be much greater. Next slide, please. So here, like I said, during the December 12th meeting, issues raised about potential grading violations. And one of the things was brought up during the October 10th hearing and the November 8th site visit. Travis did some work to the road. He did what would qualify under routine maintenance of existing roads, highways, trails, fire breaks, and driveways. He did not widen or lengthen the roads, and so therefore, there was no issue. There was no violation there. Additionally, on December 18th, grading and stormwater inspector Todd Elliott, accompanied by planning division staff, assessed potential violations, and basically determined that there were no violations. So the property prior to the applicant purchasing it had effectively been used as a junkyard. I wish I had a better way to describe it, but equipment and materials were deposited and left there. Manzanita and other brush had grown through that equipment, and then Travis and Mark, to clean up the property, had to remove some of that shrubbery, to get that junk off of the property, essentially, and also to get access for the drill rig to come in and drill the well on the property. Next slide, please. So a lot of the claims are that there's no legal easement or there's no legal access to this parcel, which is just incorrect. And so there's basically 3 easements that overlay each other to get to the parcel from Spruce Grove Road. The first is from the Leisure Properties easement, and it essentially recorded Little High Valley Road. So the Leisure Properties easement was associated with the Noble Ranch Land Division. It happened in 1967. And I don't know how big the ranch was, but it's huge. It occupied both sides of Spruce Grove Road, and it broke the ranch up into 40 and 80 acre pieces. And then the Leisure Properties, so then there's the Henderson Ranch Road was created or recorded through the Holloman easements. And then the branch road was created, well, there's the Holloman July easement. We'll get into details on that later. And then there's another Holloman easement of November. They're both of November 68 that codified Henderson Ranch Road and what's referred to as Branch Road, which is a road off of Henderson Ranch Road that goes up to the project site. If we could go to the next slide, please. So the Leisure Properties easement guaranteed access to all of the 40 and 80 acre parcels that were being created out of the Noble Ranch Land Division. What I have highlighted on the right here, it describes the project parcel, basically, stating that access to this parcel was guaranteed via the Leisure Properties easement. but it didn't spell out the road. It didn't have Henderson Ranch Road in that. It just guaranteed an easement to it. That was later perfected via the Holloman easement. But when on the left side, what I have highlighted is verbiage that's in all the easements, all of the easements, that original easements to these properties, which is the easement is 60 feet in width and is for the purpose of ingress and egress to all owners, any part of the real property above described, and their successors, interest, and invitees. Could we go to the next slide, please? So this is a diagram of the Holloman easements. The first was recorded in July of 1968, and it's for the section of Henderson Ranch Road that goes from Little High Valley Road through section 30. And then in November 1968, another Holloman easement was recorded, and it granted access to parcels that were in section 24 and 25. And if we go to the next slide. So, actually, sorry, could we go back one more? I don't know if you can see the dash yellow line. That represents another easement that the applicant worked with a neighbor, and we're going to go into that at the end, but I just want you to know that there's actually a restricted easement overlaying that Holloman easement that was more recently developed. Next slide, please. So this is the Holloman July 1968 easement, and just like the verbiage in all of the other easements of this era, each grantee, his successors, agrees for himself, his heirs, assignments, estate to permit the undersigned and or its agents to improve said proposed easements by rough grading and installation of gravel and drainage facilities. It does say that this is permissive. It does not, basically require these improvements, but it absolutely allows for it. And once again, the easement is 60 feet wide. And you can see in this diagram, the dash line on the map, the dash line, that is Little High Valley Road, and the solid line, that is Henderson Ranch Road. Next slide, please. And this is the November Holloman easement, same verbiage, 60 feet wide, and allows for, improvements. Yeah, it's just the same as all the others. Next slide, please. Oh no, the map got turned. Whoops. Okay, well, yeah, the map got turned, but the labels didn't. So anyways, this was a map that was presented in a public comment for this item, basically, stating that the road was insufficient, and why the yellow portion, they were saying that that there was no recorded easement through the Henderson property. I'm going to show you on the next slide that there is, and it's acknowledged on the Henderson grant deed. Then the McMillan maintenance agreement, that was that easement I told you that overlaid one of the Holloman easements, and that was agreed to by the applicant and the owner of that parcel. And then the 9-foot section of road that was presented here, I'm going to show you how through routine maintenance allowed per the easements and exemptions of the Lake County grading ordinance, that we can meet what we were interpreting to be the 4290 requirements for this site, meaning that it had to meet driveway standards until it got to the property. And once it got to the property, it would meet commercial standards. It would also have, fire, water storage, and, fire. Even Travis has a water truck, so that was going to be parked there too. So there would actually even be firefighting equipment on site for it. And the green box was supposed to be around the average road width is 14 feet. So there's actually sections that are really wide, and there's sections where it pinches down to 9 feet wide. So if we go to next slide, please. So this is the Henderson grant deed from 2006, and it acknowledges those Holloman easements that I referenced, that I showed you earlier, and acknowledges that they pass across that property to grant access to the parcels north of the Henderson parcel. And then the project parcel is called out right there. Next slide, please. Okay, this is the McMillan maintenance. It's a utility road access and utility easement with maintenance agreement. This pertains to the section of road where that you saw, where it is very steep and perhaps as much as 30% grade. The applicant was aware that needed to be improved. And so he approached the owner. So, you know, he has the easement through this property. He approached that owner, like, I need to improve this section of road, but this is on your property. And the owner of that property had concerns. And so the applicant, like, worked with that owner and came together with this agreement that shows, you know, Little High Valley, that was the applicant, will have the obligation to operate, maintain, and keep the branch road, that was that section of road that goes up to the parcel, in good service, repair, commercially reasonable judgment, and right. This actually, so it was a 60-foot wide easement. The owner of that property was concerned about, you know, moving the road and occupying that 60 feet in some way. And so he asked that it be restricted to 25 feet. The applicant agreed to restrict it. So on that property, even though the Holloman easement allows for 60 feet, now we have this easement and agreement overlaying that. So on that property, he can only occupy and use and improve 25 feet. And then all costs and expenses related to the branch road from and after the date hereof, including without limitation, the operation, maintenance, repair, and replacement thereof, shall be allocated 100% to the applicant, Little High Valley. So they knew this road needed to be improved, and they assumed all responsibility and all our costs for improving it. 2021. Yeah, it happened shortly after the application. Actually, I think this happened before the application was submitted to the county. During the site visit and then attempts made following the continued hearings in the hallway, we've tried to speak to those who don't want this project to proceed, and like, hey, we can do something like this with you guys, but they won't want, just like the well, they don't want to discuss this or anything really with us. You know, we're bad people in their eyes, I guess, and so therefore, you know, nothing like this has been reached for the remainder of the road. Next slide, please. So this is the 9-foot section of road that's referenced, and you can even see that the road used to be wider here. It's only being traveled like right down the middle, basically. It's probably because I don't know how long that piece of equipment's been parked there, but you know, if you're driving around that piece of equipment, it's going to funnel traffic through. But the road used to be wider. You could easily make this, I don't know that you could make this 20 feet wide, that's without actually having to grade, but through like routine maintenance, which is allowed through exemptions and allowed through the easements, you could make this 14-foot wide, no problem. You can even see that the road prism used to extend 4 or 5 feet to the right of this image, and then there's some to the left as well. So it could, without grading, without you just using routine maintenance, this could be bladed and have gravel applied to it, bringing it up to, passable standards for emergency vehicles. And once again, that's all would be allowed per the exemptions in the grading ordinance and the easement. Next slide, please. Yeah, I was afraid that was going to happen here too. So these photos we're going to show you, these are sections of the road where the pullouts are. Once again, we were operating under the assumption that we needed to meet driveway standards. So I was trying to show here that areas where they're talking about where the road pinches down, in the bottom photo, that's closer to Little High Valley Road. Erosion has, the road has been eroded there. Never mind. The road has been eroded there, and that's pushing the road. People will drive to the left, but with some maintenance, without actual grading, just blading and applying gravel, the road could be widened there. The top left is a pullout that hasn't really been maintained, but you can see where their pullout used to be, and the roadway surface there was extremely wide. I mean, maybe as wide as 30 feet at one point. Now it's not, because why drive 30? Why drive all over the place? People drive one area. It's only a couple people that live on this road. And then here's another pullout where the vegetation is starting to encroach. Everybody's driving on the left side of the photo, but you can see that the road used to extend to the right side, so that's probably 18 or maybe even 20 feet wide there in the top right photo. So I guess the intent of all this is just to say, through some maintenance already allowed that this road could meet most of the standards. That being said, it would probably require a grading permit to meet commercial standards all the way from Little High Valley Road to the project site. As such, the applicant is prepared to remove the processing facility, which would require that. So we would just go outdoor cultivation only, and then through through, I forget what ordinance was adopted by the supervisor or resolution. If we did that, we wouldn't have to meet the commercial standards. We would only have to meet the driveway standards. So the preference, the applicant would like to, keep meeting the driveway standards and have their processing facility. But if that is not, if that's not available to us, then we show how we can meet the driveway standards already. And then we'll just do outdoor cultivation and off-site processing. I believe that is the last, that's the last slide. And I'm available for any questions. Thank you.
Good, thank you for your presentation. Do we have any questions from the commission?
I have a question, not necessarily with the road, but with the cultivation. Is it going to be in-ground cultivation?
Yes, ma'am.
And on the 2 acres, what is your estimate of the number of plants?
I'd have to defer that to Travis. I'm not a cultivator. I would imagine 1,000 to 2,000 plants per acre, and those would be small plants because you're growing in the ground. These are not individual large pots growing massive ones.
So 1,000 to 2,000?
Is that all right?
Yeah.
Thank you.
If you'd like to come up to the podium, state your first and last name.
My name's Travis Lisenby. We don't plan, we're just small, so we don't plan on starting out with doing 2 acres, obviously. We start with a ½ acre and see how that goes and build our feet up to do more.
But your ultimate hope would be for 1,000 or 2,000 plants per acre?
Yeah, I would say about 1,500.
1,500?
Yeah.
Okay.
Okay, so I just happened to do the math on that while he was talking about the water. An acre foot, and I was under the impression we were just going to go with gallons from here on out.
That is once we update the cannabis regulations.
Oh, I see. Well, so anyway, just so everybody knows, according to the interwebs, 1 acre foot is 325,851 gallons. So 4.2 acre feet would come out to 1.368574 gallons. That's roughly 1.4 million gallons.
Yes.
At 6 gallons per plant per day, that comes out to 68-day growing season.
Okay,
Just
I know. We've had this before. I really hate the 6 gallons per day because that was based off a Scott Bauer study, which was based off of Humboldt County growers back before the passage of Prop 16 or Mount Cursa. And that back in those days, if you were growing too many plants, here, for example, here in Lake County prior to that day, if you grew more than 49 plants for collective cultivation, you were subjected to fines, penalties, and potentially arrest. And so therefore, instead of growing, 1,000 plants in a quarter acre or an acre, instead of growing 1,000 plants, they grew 49 of the largest plants they could possibly grow. And so, yes, those plants probably use more than the 6 gallons per day per plant. However, the reality is now you grow a lot more plants, you grow a lot smaller plants, and each plant uses a lot less. So an acre of the plants that are the kinds that Scott Bauer studied, that would be like 250, 300 plants that would fit an acre when they require ladders to harvest. But that's inefficient. No business would be successful in this day and age if they needed a ladder to harvest their plants. So now the idea, you never get them above shoulder height because then it's, and also you want to restrict that cultivation season. Also, another reason you don't want to get them that big is because they're subject to wind and weather and stuff like that. So it's just, I always it bothers me.
You know that I'm a pear farmer and I have 300 ladders in my backyard. But back to the issue, that's the study we have.
I know.
So I would encourage you to do further studies that are specific to Lake County.
Well, I have empirical data from my clients. We have to provide annual reports every year. And in-ground cultivation, from my experience, these are average because everybody uses different irrigation systems, everybody uses different strains, cultivars, different things like that. But in my experience, in-ground cultivation with the white plastic mulch, it's about 1.8 acre feet per acre of canopy. Sonoma County, that same resource that I cited for water use estimates, their estimate is 2 acre feet per acre of canopy for outdoor cultivation and 3 for indoor and greenhouse cultivation per acre of canopy.
So I'm going to have to translate that unless you say gallons.
Yeah.
So I guess my question is, what's the length of your growing season?
Once again, I'd have to defer to Travis on that one.
We typically plant.
Please come up to the podium and state your first and last name one more time.
Travis Lisenby. Growing the little plants, you plant middle of July, and then you're harvesting a week before November 1st. So you're, 4.5, 5 months of a outdoor season.
Okay, so that's about 3 gallons per plant.
Yeah.
Thank you. We're getting closer. The other big difference that I'm seeing is between the study, it was done in Humboldt County, which I believe is much more humid than Lake County.
Yeah.
So there's that.
Yeah, I mean, I believe that, that was Humboldt County when they were allowed to do 99, and I know some of the farms in the Scott Bauer study, they had, farms that had 200 or so plants in there, but still, they were still growing the biggest possible plants, and I know here in Lake County, some of the legacy growers were growing. I mean, I've been sent and showed pictures from my clients, like, look how awesome this is, and like where they're like sitting on a ladder in the back of a truck to get to the top of their plant, and like you're not going to see that. That doesn't happen anymore. That was because we were limited in Lake County to 49 plants, where you could do 99 in Mendocino, or 48 actually. I'm saying 49, but it was 48. In Lake County, where you could do 99 in Mendocino and Trinity and Humboldt. And so if you're in Lake County, you grew the absolute biggest plants you possibly could grow in those days.
Any more questions for the applicant?
Yes, back to the road. So again, there are certain areas of the road that, and I know that some road improvements have been done, but like for instance, the berms, the berms that were set up to allow the water drainage to cross, I question some of those berms too, whether again that's safe for emergency vehicles to get up and down the road. The slope is a major issue, it being well over 16-20%, and really ideally should be paved, or should be a solid surface rather than the gravel surface that it is. While the work that's been done is great, but is that really up to the 4290 standards? And then I'd say, again, it just being in specifics, the turnaround at the top of the road. And this is one thing that I failed to mention before, but as Mike Wink had mentioned to me that he did take a drive up that road in his big fire truck or whatever truck he drives, and he ended up having to back down the road because there is not a turnaround there at the gate. So it's really ideally that gate should probably be moved back so that there is a turnaround or a 3-point turn. Should anybody end up driving up that road, whether it's a fire safety equipment or anything else. So in the ideas is I know that a lot of, or some of these improvements, especially that steep slope section, is past the residential homes that are located on that road. But if there was a fire that originated up or beyond the location of this project site, how do we make sure that it can be attended to safely and keep, everyone downhill of the project safe? And before you continue, I do want to add one more comment, so that, again, I failed to mention before, but I do appreciate everything that you're talking about with the project. This is one of the best project sites I've seen, and I'm not just talking cannabis, I'm talking, other projects and stuff. It's, the project site itself is very clean, well maintained, well thought out. So again, I just want to make note of that and appreciative of the work that, has been done thus far on the site. But what can we do to make sure it's safe from Spruce Grove up to the site?
Thank you, and I think I could speak for Travis because he's done all the work. Thank you for acknowledging that. But I want to make it clear what I'm referring to improvements that will be made should the project be approved. Should the project not be approved, then none of the improvements are going to happen. And so speaking, yes, the road dead ends at the gate right now. It will be a requirement that we provide some space. The road, the gate can't be right at the turnoff of the road. There's requirements that, when we're talking about 4290, once you get on the property, it's going to be 20 feet wide. The section of road that's steep, Travis was already planning on paving that. Obviously, he's not going to pave that section of road, though, if it's not approved. The turnaround at the end, there would be a Knox box. So the next time Mr. Wink drove up that road, he would have a key to open the gate, get in, access. Hopefully, if we're allowed to have the processing building, he would be able to access a water tank, a 10,000-gallon metal water tank that already has hookups ready for him to take the water out of and fight whatever fire he needs to fight there. There would be adequate turnaround areas. There would be parking areas. There would be a restroom, and actually, at another site that was used as a staging ground for a campaign fire. The firefighters were very appreciative that there was a restroom available to them at their staging area, their rendezvous point. And so all of those things would be available. And then I don't want to forget about the water bars. So the guiding principles for compliance with 4290 come from a documented SRA fire safe regulations. I don't believe it mentions anything about water bars, but I do know, so my background is in the timber industry, forestry. My master's degree is in forest hydrology. And I know that CAL FIRE requires water bars on roads for drainage, for protection of the, because they're not just firefighting, they're forestry and fire protection. So as far as forest practice rules go, they require adequate drainage, but those rules don't necessarily apply to cannabis. For cannabis, we have to adhere to the water board rules and county standards and fish and wildlife rules. But so I guess what I'm saying is CAL FIRE equipment regularly travels across water bars, because whenever they're fighting a fire on timberland, it's a requirement that there are water bars in those roads.
Thank you, Trey. So public input is open, so if whoever would like to speak, you'll be given 3 minutes. Say your first and last name for the record.
Hello, my name is Tom Lasik. Joni Henderson and Margaret Kimbara have offered to yield their time, if that's permissible by the commission.
We'll limit the time, combined time, to 7 minutes.
7 minutes? I think I can swing that.
Okay, thank you.
The first thing I will talk about is homeschool. I think that last hearing on this topic in February, I think County Council almost got it right. It's a little concerning that things have taken a different course. The first thing I want to point out is that there's no longer any dispute that Ms. Henderson's homeschool is a legitimate homeschool. She has the affidavit. She's complied with all state rules and requirements to have a homeschool on her property. I believe that last month, County Council was correct in recognizing there was a problem with the language in the county code that was creating a situation where her homeschool was denied equal protection. And I want to provide some additional clarification, because I think, with all due respect, the explanation given by County Council was a good faith effort, but I think it sort of stumbled and tumbled through it. In the county ordinance, Article 68 defines what qualifies as a school, and it has a special exception for the purposes of cannabis that denies homeschools that same protection. And when combined with Article 27, which has in 3 locations a setback of 1,000 feet from schools, created a situation where her school was denied the same protection as other schools. County Council was also correct in pointing out that the language that's in the County Ordinance 68, where the definition mirrors the language that's in the State County Code as it pertains to health and safety. And that portion of the code pertains to medical marijuana, not recreational marijuana. County Council was also correct last meeting or last hearing that the portion of the code that relates to recreational marijuana is in the business and professions section of the code. And in that section of the code, it does have restrictions on setbacks from schools, and it makes no distinction on the provenance of the school. It doesn't say anything about whether it's a public school, private school, homeschool, or any permutation thereof. And this was pointed out by County Council last hearing. So in that light, the homeschool would enjoy equal protection. County Council was also correct in pointing out that the Planning Commission has the authority to remedy this because the state allows the Planning Commission the authority to improve safety standards that meet or exceed the state standards that are in place. And it was appropriate for County Council last month to recommend to the Planning Commission to use the setbacks that are in the Business and Professions Code, which required a setback of 600 feet between the property line of the homeschool and the property line of the cannabis operation. And you have the authority to do that because right now the county code is out of alignment with that. Now, if that is applied, I'm whipping through this, so we're going real fast. The way the language in the county code is different than it is in the state code. Now, in the county code, it's 1,000 feet as measured from the school property line to the cultivation site. But in the state code, it's different. It's the property line of the school and the property line of the cannabis operation need to be 600 feet apart. If that's the case, then this one should be denied because they share a property line and they're 0 feet apart. So for the sake of health and safety, it should be denied. And then, by the way, the local jurisdictions do have the authority to make variances, but not on health and safety. Well, they can make variances on health and safety, but it has to meet or exceed the state's requirements. It can't be less. So in this case, they have 0 clearance, and 600 feet is what the state mandates. That's a safety requirement. So in that light, it should be denied. And by the way, this isn't some sort of hypothetical legalese mumbo jumbo that has no relation in reality. We have a child whose life depends on the decision of the Planning Commission. Severely immunocompromised, had to be removed from his traditional classroom because of his health and put in homeschool for his own safety and recovery. So keep that in mind as you go through this, and you have the authority to impose stricter safety rules. So let's now pivot to 4290. There's some things here that were not really properly articulated to the Planning Commission. The portion of the state fire safety regulations that apply and get their authority from 4290, 4291 are the Title 14 safe fire regulations. First of all, it says in the definitions for a driveway, if you have a commercial operation involved, you can't use the driveway definition. You have to use the roadway definition. Okay, so you can feel free to look at this. And this is going to apply for every case that comes before the Planning Commission, so it's important that you know these. Secondly, it does not apply to just the property line, the portion of the road that's inside the property line. It applies to all roads within the jurisdiction of the state that are within a very high or high fire safety zone regulations. There's no dispute that this applicant intends to use Little High Valley Road as their primary means of ingress and egress. There's also no dispute that the road in its current state does not meet 4290 requirements. There's been talk about the narrowness of the road. It's 14 feet wide, it's supposed to be 20. The other one is the hairpin turns. There's at least 2 that do not meet the standard for curve radius. As Commissioner Rosenthal pointed out, there are areas, large areas, where the road exceeds the minimum requirement of 16% grade, and the road's dead end requirement is longer than a mile. And that is measured from Spruce Grove to the operation site. Those are all violations of the 4290, and these aren't optional. These are specifications for safety. They are allowed to put in, If
you would like to finish your comment, I'll give you
Yes.
another extra minute and we'll go
Thank
to
you.
the next speaker.
I only have a couple pages, so it should be good. So the road, I'm not sure how they can possibly, unless they have some magic wand that can contract time and space, reduce the length of the road to less than a mile. I would say that having to regrade a road to comply with the 16% grade would be more than just general maintenance. But in its current state, and in the current permit, there doesn't seem to be any language that says they're going to improve that road. If they want to put in another road and make it 4290, that is allowable, but that doesn't seem to be the intent of this application. And again, it's a fire safety road. You can have variances, but they have to meet or exceed the state requirements, which in this case are the Title 14 fire safe regulations. And if you have any questions for me, I'm more than happy to answer. But thank you for your time.
Thank you very much for your comment. Anybody else wish to speak?
I need to sign in again.
You can state your first and last name and you can sign afterwards. That's fine.
My name is Joni Henderson. It is my son in question that has the health concerns. I'm sorry. This is real for my family. Nowhere in any of this, thank you, Mary, I appreciate that. Am I hearing the applicant even acknowledge this? And I've come up and spoken multiple times. Nowhere is this being acknowledged by them. But they present themselves as so neighborly and talking to the neighbors and offering to work it out. No, they haven't. I have spoken on this multiple times. This is real. Those protections for other schools, places where children gather, churches, school evacuation sites are even included and are afforded protections. Why? Because there are serious health concerns with this product. It is a drug. I'm not arguing whether or not it's a good drug or not. It is a drug. It has impacts. It is not recommended for children's use. Why? Because it is a drug and it has impacts. My home is 400 feet from the property line. There is no separation between our property lines. I am downhill. It's a steep hill, I'm downhill. But I'm told, oh, no. They have to register all the chemicals they use. They have to follow the law. They have to this, and this. We have gone through multiple times in public hearing all the places where their application did not follow it, did not follow CEQA, was ignored. They've explained away 8 acres of clearing. Oh no, it had to be done for some car removal. 8 acres was cleared without the benefit of environmental review or permit. But you're asking me to trust you're going to follow these other rules when you're not being, when they're not put under such a microscope as they are now. You're asking me to put the health of my children. They're not following the rules right now. But I'm supposed to just be patronized and told, oh, no, they're doing a great job, it's fine. No, it's not. No, it's not. Please hear me, it's not. This is a child. And this matters. I don't have the benefit of a presentation. I didn't know that was an option. Or I would show you pictures of my children. I was very enlightened by the view of the easements. Those easements were set up for residences out on property. They were not set up for commercial purposes. They're not. It was set up for commercial. And my understanding is this, as Tom just said, this operation would now put it into commercial. The road doesn't meet it, and I don't think it ever will. And the comments below that the road had been this wide, 25 feet, 30 feet, no, it hadn't. No, it wasn't. Never. Where's the proof of that? The residents who have lived here for decades are telling you, no, it's not. Why are our words not being mattered? Why don't they matter? Why don't you hear us? That is not the truth of this road. I don't have a benefit of a presentation to show pictures of the water bar that they put in that has now caused erosion to the point where my mother, who's here, she can't drive her car down the road because it's eroded and then it has to come up over the water bar. Her car water bottoms out. She has doctor's appointments. So I go down and fill it in, and because all the water is diverted, it washes it out again. You see the erosion down the hill of all the gravel being washed away. Where's that mattering? It's being done without permits. Why are they not being held to the standards, to be accountable? They go over these bumps and they're not considering what they're doing to the residences, but yet they're saying that it matters, they're being good neighbors. No, they're not. The residents, the neighbors are here telling you, no, they're not. As far as the water usage, if I could please comment on that. I know there was a question on that. From in their application, they have a statement at 12,300 gallons per day. The average home, about 300 gallons with the water efficiency. I think that's a pretty safe estimate with 300 gallons. That would add for our water usage in our little area, 41 homes. 41, not 4.1, 41.
Sorry, that is the 3 minutes with already a time extension. If you would like to wrap up your comment.
Yes, I would. Thank you very much. That's a huge amount of water.
So that's 3. That means I would only be allowed to give you an extra 2 minutes.
Okay, I'll talk fast.
Okay.
We've all testified, my neighbors in our public hearing, that we have water issues. My well is on my nephew's property. It was all part of my parents' original ranch. It's part of the original ranch. That's where our water comes from. Not just me. You guys please understand, it's my whole neighborhood. We've told you. We have water issues, even outside of drought issues. My neighbors have brought testimony, what they experience. Adding 41 homes of worth of water to our area, please consider this is significant. The legal definition of the road, the fact that it's so steep, it's 34%. You can get up it with four-wheel drive if it's with some spinning. There are not pullouts. I really question whether or not it could meet. How do you deal with that slope? What are you going to do when you have workers up there and if they get injured, an ambulance having to get up there? What then? Who's responsible if they can't get up there? What about if there is a fire in our area and all of us, the homes that live there, we're trying to get out and equipment's trying to get in? What happens? These are real life safety concerns. I can't remember who said it, but there's going to be a fire eventually. We're in that very high fire danger area. There will be. We're in a sea of unburned from the Clayton, the Jerusalem, the Valley Fire. We're in this unburned area. We mitigate as much as we can, but we know it's coming. What then? Who's responsible for approving a permit that does not meet safety standards on the roads that are quite clearly stated? It's not an opinion. It's requirements, standards that have to be met. They went so far in the original application to claim that the burn marks on their property was from the Clayton fire. That's insulting. My brother lost his home, animals in the Clayton fire, and they're pinned to a place. It was because they had a control burn that they left, and the winds, on a windy day, it escaped and it got into the brush. So my neighbors and I went running up there because we got phone calls, because it's above me, seeing on Facebook. It's on Facebook, so there's no it is real. They left the property, but they're supposed to be a good neighbor and we're supposed to trust this. This is their behavior.
And that's a wrap for the time.
Thank you.
Thank you very much. Anybody else wish to speak? Just first and last name for the record, please.
Bill Landers. And my property, the easement runs right through the middle of my property. I've already mentioned that before. And now they're talking about they want to widen the road. That we just put ditches in for water runoffs and all that. So all that's going to be destroyed in front of my house and redone and all that. So when they do widen the road, it's going to be great because I'm going to have more traffic going through there. I'm going to have more people speeding through there. I have my grandkids that come through and visit. No, it's not safe for that. We got the road just the way we want it, and we'd like to keep it that way. We do have that, like I said, about the water issues. A couple of years ago, my well went out. It never has. I've been there 25 years. Even filled up a 30,000 gallon pool with it. It has never ran out. Now all of a sudden it ran out, and we did have a drought. But when they filled up their tanks, then ours went dry. Mine did. My neighbors did. Joni's went dry a little bit.
What year was that?
What?
I'm sorry, up here, Commissioner.
Where at?
What year was that?
That was 2 years ago? 2 years ago. Yeah. So don't know what happened with the J.C. Crandall and Santa Barbara outcome on that, and it sounds like nobody does right now. But it still has something to do with the permission of the owners that have lived there and should give them the right to help make that decision whether or not we want that right there. And right now, having a cannabis grow going through our properties, all that changes our whole lifestyle. It's fine for them. They just get to go up there and they get to grow. Our lifestyle changes. Everything changes around our property and whatnot. And that's not right. I don't know why we have to make all these changes and be disturbed and everything because they want to do a grow. Travis already has a grow. He's already doing it somewhere else. Why do we have to have it right there? Just don't want it. So just wanted to present all of that and hopefully change your all mind that we're happy the way we were, and we don't need this. There's too much going on right now with that. And as far as the fire, yeah, if there's a fire up there, yeah, fire department's not going to get there. It's too much brush, too much trees, all that stuff, and the road issues. To which, going with the road issues, like I said, it goes right through my property. That is going to change, and I am not going to be happy about that. So, thank you very much.
Thank you for your comment. And first and last name for the record, please.
My name's James Wright. I've been driving these roads for 40 years, and I'm very upset about this. There is no way you can make this road safe, fire safe, and accessible to pass each other, especially during a rain where they park them vehicles. That's a nice look at how wide the road is. You can't get on that side of the road. You can't get on either side of the road. You go straight down. I've pulled many people out that have drove down these roads in the wintertime, and it is not accessible but one lane. I've backed out of this road 3 times this year. Once for a dump truck. I had a trailer hooked up, empty luckily. I backed out on the pavement on a blind turn, and it's extremely dangerous. Somebody is going to get T-boned as the traffic increases, absolutely. My mother-in-law, the first driveway to the left, anybody that's been on the property, there's a huge rock on Bill's property. All that road is on Bill's property. It's not on the proper easement. They stated that we'd definitely have to have, if we moved it onto the proper property line of the 60-foot wide easement, it'd have to be engineered, obviously permitted, and it's major. There's no way with water you're going to get access to any of this road passing in so very few places. And that water bar they put right where the road goes to Joni's property, you can't see her property from where they built the last water bar on Spruce Grove Road before they built the road up that steep part. I just went there this week. I've never been up that road till this week. At any rate, the road is literally the water bar, and the way they've done this, it has taken Joni's mother's access to her freedom away with her car. I've seen her many times as I'm repairing the roads, because my mother-in-law's road enters Little High Valley Road, the first driveway literally to the left. I own the property up above 20 acres. At any rate, I don't know how they could even get this passed. My son-in-law just got retired from the fire department over health, smoke inhalation with open heart surgery over the problem, which is irrelevant to all this. I discussed all this with him. He said, Jim, them roads do not meet any standards for CAL FIRE. He was a captain for CAL FIRE in Humboldt County. And he mentioned the fact that I don't even know how they're permitting that. He said, because it's not safe fire hazard, because that's the, burn area. I don't know how to explain all this. But I had about an hour conversation with him about 2 weeks ago. And he's been on the property, so he knows the circumstance. He says, no, that is not accessible. There is no passing. He said the fire department would have a huge issue with that during a fire. And Travis is right that once you get to the top of their property, it gives them a place to base. They mentioned the fact to me, my son-in-law, that my corner of my property is cleared about 3 acres. It would be a good base point as well for the fire coming through the valley. Because we've talked about that. He's camped on my property. So we're, vividly aware he's gathered, down firewood. But at any rate, I don't see any way. So obviously that's my 3 minutes. I don't see any way that they're going to improve this road without an extreme amount of expense. And the steepness of that road going up to the property, I did it this week for the first time. I'm shocked how steep it is with the water bars. There's no passing on it. There is no turning around on it. But bottom line, as soon as because I've done it 40 years, as soon as you get onto the side edges of the center of the road, you go down. I know for a fact because I've been down. I got 3 foot off the road I have.
And that's the
And I went
3-minute
straight
time,
down
sir.
all 4 wheels.
So thank you for your comment and
Thank you.
your experience down on that road. So it's definitely helpful to kind of hear what the neighbors have to say, what they've dealt with for all this time. So first and last name?
Travis Lisenby. So yeah,
Can we check the timer?
A lot of concern about the water bars. The water bars are put into place so the water doesn't just run right down the center of the road and pick up speed to dig out the road like how it was before I came in and put some base down. So the water bars are for the winter time to, they're at a slight angle, not too steep where you want to wash the gravel out, but enough to get where any weed, leaves or anything get in there, it don't clog it up and overflow it. I put the money in the road, so I go up in the winter while it's raining and walk the road, make sure that it's all flowing right. So, as it comes to be summertime when there's no rain, we grade off those water bars so the road is smooth. But as they are, the water bar is no more than 5 inches. So it's not any worse than what the ditch was that the water was picking up speed to get down the road. And, as the farmer up there, I do have respect for the neighbors. I had told Joni in the past, I'm willing at the Y where it goes to her place, I put in a automatic gate there just to deter any traffic that may go her way. I put up signs that say Little High Valley Ranch up this road, just to get people so they don't even go bother her. And with putting that gate in, like I said, a automatic gate with a metal post, so it's there for long term, not just a wooden post hanging a gate that's going to break next year, So I'm a fabricator myself, so I do all that work. If there's any questions that you guys have for me, I'll be more than happy to answer any questions.
No questions? Mark?
No.
Commissioners, good to see you all.
See you.
Some ancient history here. I just want to clarify some things.
We just get the first and last
Michael
name for the
Green.
record. Thank you.
Early in the days of cannabis regulation, again, Proposition 64, 2016, and the legislative framework beyond that created the first definitions. The distinction between a school and a place where youth gather was to accommodate for things like a church that did have, for example, Boy Scout troop, or a community center that allowed youth events and stuff like that. So it's not that one or the other, right? It's just because youth gather there. But if the claim is that the school is a school, then you follow whether it follows the school definition. One reason why the small homeschools was not included in the county language, to my knowledge, originally was we couldn't even confirm. You can't get a list from Lake County Office of Education where homeschools are and aren't. So they would have to kind of self-report, as they have in this case. But the irony in me is the more you claim, oh, we're a school and all that, I'm kind of going, well, 4290 standards, if people are at fire risk for a cultivation site where plants are being grown versus a commercial property or even a home residence where education is going on, you know, why, if we're that concerned about fire safety, let's do it with an open mind and an open heart. To the extent site visits go on and stuff like that, I appreciate that. I definitely think that can add context and education. I do want to remind folks of the substantial evidence test. You know, site visits are really useful if you have follow-up questions of the applicant or of staff or of the opponents and stuff like that. Probably don't want to like necessarily interject your own understanding, or you don't want to end up testifying. So it's kind of a slippery slope there. So I just wanted to kind of point that out there. And I heard an offer from the applicant, a reasonable one, I think, that if they were to remove the processing facility, all this argument over the 4290 standards would go away, and I think that might be appropriate in this case. I'd also like to point out that by right agriculture, we wouldn't have that. If they wanted to put a hemp farm up there, if they wanted to grow grapes and all that, absent the introduction of a commercial facility, we wouldn't even be talking about 4290 standards. So be careful what you ask for. I'm kind of reminded of the Farmland Protection Zone. One reason we're seeing projects like this out in the hinterlands is because they're prohibited, basically, from bringing an affordable project into the built agricultural environment, where the roads are there, the power is there, the easements have all been worked out. You know, it's kind of an ironic thing. We've seen the development, the kind of a bathtub ring of where good projects and good applicants can't really bring them forward in the places that they would otherwise because of opposition there. They've gone where the zoning has permitted them, and they've kind of paid a price for that. So I do feel that there's been evidence of concern over the road standards and how the improvement of the road may be either infeasible or not permissible, but if they're willing to pull back the processing facility, avoid the road improvements, I think it would be a more affordable project for them, and I think it may be more palatable to the community. Thank you.
Thank you very much. Okay, that's fine. And that'll be 3 minutes.
Tom Lasik again. It's good to see Mr. Green back in chambers. It's like deja vu. Just a couple things I failed to mention. This won't take 3 minutes. There was a mention by county staff that in the past they used to apply 4290 in a certain way. It's been clear that that's not been consistent. I think I pointed out in a letter that I think is green sheeted, that in the past they have required other developments, not just cannabis, but you know, it's not uncommon for municipalities to require 4290 compliance on property that they don't own. In the case of Highland Farms, Mr. Chavez, I think you were in that hearing last May. In that one, the county required the applicant to improve over 1,000 feet of road, access road that wasn't on the applicant's property. In fact, it was on county property, and it had the similar situations: narrowness, steepness, hairpin turns. And it was about 6,500 yards of disturbance that would be required, which is about the size of this city block, about 3 to 4 feet deep. The other thing that to mention is, it was mentioned that Mr. Wink didn't put anything in writing. Well, in fact, he did. And in 2021, you have in your public comments a letter from Mr. Wink on the online version. I think it's on page 58, where he makes it clear that any private road or access road that's going to be used for the project must be compliant. For the future, I strongly urge the Planning Commission to take a look at the fire safety codes. Pretty straightforward. The driveway does not apply here, not only because it's commercial activity, but there's also more than 4 residences on that road. We've had 3 here. Another one was mentioned. There's a feeder road that goes into it. So there's more than 4 residents that depend on Little High Valley Road. So it does not qualify as a driveway under state Title 14 regulations. In its current form, there's talk about, well, maybe we can be willing to do this than the other, and maybe that sounds great. But if you can't shorten the road, you still have one showstopper. And in its current form, it should be denied. If they want to come back with something else, maybe there is something to work with, but not in its current form. Thank you very much for your time. Please.
Excuse me, not on the roads, but on a prior comments, you said that the sorry, I don't remember your name, but has an affidavit for verifying her homeschool?
Yeah, Ms. Henderson, so when you have a private school, whether it's a homeschool or a magnet school or a private military academy, you're required by the state of California to have a private school affidavit, which she does have. And when in the ruling Jonathan L. versus Los Angeles County, which was ruled on October 8th of 2008, 888, the courts ruled that homeschools are a species of private school. That's their language. And so she does have a legitimate private school.
I don't recall that we have that in our...
She mentioned it in the last hearing.
No, I understand that, but I don't have that.
I'm sorry,
Paper or...
Yeah, I think she submitted it in the
Did I miss
last
it?
hearing. It may have been green sheeted. This is in the pre-meeting comments about Granicus. This is one of the things that I sent to the county that didn't necessarily make it in time for public comment in the normal fashion.
Oh, okay. Thank you.
Okay, and that's all I have, but thank you very much for your time.
Thank you, Tom.
Travis Lisenby here. I just wanted to say one thing about the homeschool thing. My wife does homeschools my younger kids, and we also have an affidavit, and all it takes is going online and signing it out and getting it right then. So, in Joni's case, her 2 kids that live at the residence are the homeschoolers, so it's not like there's outside people coming to it. And I also don't know how necessarily she homeschools if she works full-time also. So just wanted to bring that to your guys' attention. Thank you.
Thank you for your comment.
Hello, Tree Sherrill. The gentleman before Travis, stated that the road was over a mile long, but the letter submitted by Brian Hall states that it's 0.9 miles from Spruce Grove Road to the project site, and that also includes about almost 0.2 miles on Little High Valley Road, so it's definitely less than a mile from Little High Valley Road to the project property. There was also that same gentleman earlier had made a comment about grading the steeper section of the road so that it is less than 16%. The 16% mark is if it's above that to meet the 4290 standards, it has to be paved. Whereas if it's below 16%, it does not, gravel or other adequate road surface can be used. One thing I thought of earlier, multiple attempts were made Ms. Henderson made the comment that we've not reached out to her on, I have the dates, on October 10th in that room next to us. I tried to speak to her on November 8th at the site where we met. It was by a large rock. There was a large rock where we all met for the site visit on that day. And both times I said, I tried to approach, I wasn't confrontational anyway. I wanted to hear her out both times. She looked me in the eye and in no uncertain terms informed me that she did not want to speak to me at all. Additionally, when that 9-foot wide section of road, right when Travis was working in that area, the son of one of the neighbors pulled a gun on him while he was, and that's one of the reasons why that section of road was never improved, because obviously. And finally, as I mentioned earlier, we're willing to remove the processing facility from the proposed operation, in which case we would meet a lower threshold for compliance with 4290 rules that is codified by the Lake County Board of Supervisors per resolution number 2019-124. And so those are the requirements that we would be meeting, and those are specific to outdoor cultivation only, no other activities. And I'd like to remind you, the neighbors have come up and said how dangerous this road is in its current condition should there be a fire. This approval of this project isn't going to make that road more dangerous. It will make it less dangerous. It's going to require the commercial activity that's occurring to maintain the road to their standards. It's going to require firefighting infrastructure at the project site. I'll stop right now, but I'm available if you have any questions.
Thank you. Any questions for Trey? All right.
Thank you.
Anybody else wish to speak?
There's two people
Oh.
on Zoom.
Can I take the two people on Zoom first, and then we can come back to you? Yeah, thank you. All right, we got the first Zoom.
Donna, please state your first and last name. You have 3 minutes to speak.
Donna Makowitz from Clear Lake Oaks. Please deny this project, and I reference page 17 of 30 on 25-310 Property Management Plan. As the commissioner mentioned from her site visit, these conditions cannot be met, and the applicant himself just spoke to the fact that the project cannot meet bullets 4 and 5. It says all weather roadway surfaces do not have standing or flowing water that vehicles must travel through, and the roadway for this commercial use shall consist of a minimum of 20-foot wide gravel roadway, and also the maximum roadway slope for any road is 16%. Thank you very much.
Thank you, Donna. And we had one more person on Zoom.
Maria Khan, please speak. State your first and last name, and you have 3 minutes to speak.
Hi, my name is Maria Khan. I would like you to deny this project. I have several comments. The first comment I have is my distaste for the county council kind of massaging the requirements around 4290. It is either compliant or non-compliant. There's no kind of here, kind of there. The second comment I have is that easements are not on the applicant's property, and I want to know what right do they have to make changes to someone else's property with regards to the road. I have an easement on my property, and I tell you, I'd be in fits if someone started a commercial enterprise and a 7-day-a-week operation to come through my property and widen my property to accommodate their commercial project. Next is drought recovery is not just 2 years of precipitation. Drought recovery takes years for the water to be restored. And I personally went through losing my well back in 2021 and had to pay over $35,000 to install a new one. And my old one never came back, even though we've had several years of water, recovery, precipitation. My next comment is homeschooling, public school. I also homeschooled my child. I actually registered with the state or county, and I used the California Virtual Academy curriculum, which was public school online for my child. And I had to do attendance and provide all that stuff to the county, to the state, showing that I was educating my child at home. And it is a legitimate form of education. As you see, there's a lot more people homeschooling now. Also, homeschooling was in effect far longer than any cannabis industry, and to try to massage the rules to accommodate cannabis is rather unpleasant also to me. So my last comment is, it doesn't seem fair to me that applicants are allowed unlimited time to speak when the public who's going to be impacted by these projects is always cut off at 3 minutes. I think it should be, they should be restricted as well. Everybody has the opportunity to read their plans and go over the materials, and for them to come in and present 20-minute long presentations and then have only 3 minutes as a counterpoint person does not seem fair to the public. So those are my comments, and I ask you to deny the project. Thank you so much.
Thank you for your comment. All right, we have another speaker in the chambers.
Thank you. Homeschool is a real thing. We have real curriculum. My program's accredited for more than 1 year, okay, multiple years. We send in our work. It's completely accredited. It's a real thing. It's not flip it. And I find it distasteful also that somebody else would dictate to me whether or not I have fellow schoolers, homeschoolers, bring their children over to see the farm and experience farm life and do garden classes. I'm sorry, really? Who's he to say this and enter this as fact? But we've been experiencing this the whole time, dismissing our comments and no, that's not the truth. This is the truth. No, the neighbors get to speak. We live here. It matters. Please hear us. As far as our concerns on the road, there's a few residences that live there full-time, 5. The road works for us. Our concern is when this doubles or triples and it's constant because of the commercial traffic in and out, the additional use of the facility, the fire hazards that this incurs, the dangers that incurs of all this traffic up and down. Those are real concerns. As it is right now, the road suffices for the smaller handful of residents. There's 5. That's a good number, but there's 5. And I think it is incorrect that it would be the building being pulled from the standard, or from the application that would mean it no longer has to be 4290 compliant. I don't think that's true at all. It's any building permit, new use or new road construction would trigger 4290, not just the removal of the building. Please, County Council, perhaps you could clarify this, or we need more information on this, but I don't think that would cause it to no longer have to comply with 4290. It is a commercial operation. I thank you for letting me speak.
Thank you. Did council want to give any feedback on that question from the applicant, or from Joni, is that correct? Yes. Yeah.
I don't recall hearing a citation as to why removing the processing facility would remove the requirements for 4290, 4291.
I can give it, it's like resolution 2019-124.
Chair, could we take a 5-minute recess, please?
Sure.
Thank you.
Yeah, we'll take a 5 minutes, so we'll be back at 11:06. Thank you. I should have said. Check, check. We do have a time of 11:07. We went over a little bit. But now that we're call the meeting back to order. Is public input is still open? If anybody else wishes to speak.
You have one hand, isn't it?
Okay, we do have one hand in the Zoom room.
Maria, state your first and last name, and you have 3 minutes to speak.
Oh, I'm sorry. I didn't have another comment. I think my hand was just left up. But I would
Thank
like
you.
to apologize for any other comments that came over while it was supposed to be muted.
Chair
Sorry.
Chavez, if it pleases the board, we do have clarification on the discussion we were having during the break.
Okay.
Information. Commission.
If I may. So on August 27th, 2019, the Board of Supervisors had signed resolution number 2019-124, and this has been applied consistently to these projects in that the cultivation activities that do not include structures are to be treated as agricultural activities, and as such are held to agriculture road standards, to which there are no road standards. With that, back to my conversation with the County Fire Marshal Jack Smalley and CAL FIRE Assistant Chief Mike Wink yesterday, we did discuss removing the processing facility as an option for this project to reduce the scope of the project and limit impacts that would not require any further road maintenance. And that is something that the applicant and consultant have stated that they are willing to do. And we do have that resolution, Resolution 2019-124, that would support that.
Okay, thank you. I guess I have a question for staff or for Director Turner. If the project changes, well, if the applicants agree that to remove the processing facility, would the project have to go back to get rewritten and then brought back again? Or do we just cross it off here and
We would make note of that modification here today. That would be fine.
Okay.
Yeah, and then we would make note of the file that alteration had been done, or that amendment to the project description. So they would continue to operate in compliance with the amended project description.
Okay. Very good. That was just a question regarding for the options that we have coming up here soon. Would it either be to continue the project for those changes to be made, or if we could do that today? So that clears it up. Thank you. All right. Public input is still open. If anybody else wishes to speak. Okay.
Tom Lasik again. Just a quick clarification. The measurement on the road was from the gate. I actually was out there, I believe it was Sunday, and measured it myself, and it was 5,190 feet from Spruce Groves Road to the gate. However, the requirement is for the entirety of the road, and since we don't have permission to go across the gate, there's several hundred feet beyond the gate, and that has to be included in the calculation when the CAL FIRE safety setback is 5,280 feet. That is the maximum allowable for a dead-end road for parcels greater than 20 acres. And whether or not there's a commercial activity on there or not, because it is now defined as a road, and because there's more than 4 residences, then that portion of the fire safety code still applies. I saw nothing when I looked at the Title 14 that says, oh, if you pave it over 16%, then it's okay. Exceptions can be made, but no more than 20%. Under no certain circumstances. So I would encourage the Planning Commission to, in the future, maybe get a copy of that section of the ordinance, because it's fairly short, fairly straightforward, and these things keep coming up over and over. Just because they said they used it in the past doesn't mean they've used it correctly. So with that, I thank you again.
Yep. Thank you, Tom. So seeing that, well, I guess would we have the applicant come up and state that they're going to, or do we just assume, since they already have stated that they would remove the processing facility?
I would confirm that with the applicant.
Okay. So applicant or whoever wants to come up, yeah.
Travis Lisenby. Yeah, we would take away our processing and just do the cultivation.
Okay, so the processing facility is out of the scope of the project, and it would just be outdoor only?
Yes, sir.
Okay, so that being said, kind of what we've discussed, then the road improvements would not apply. Is that correct, Steph?
How is that a good thing?
Oh, I didn't say it was a good thing. I was just kind of seeing the options that we have here on paper, and the things that we have to use to make our decision to approve or disapprove the project.
Yeah, I'm not asking you specifically, I'm just posing.
Oh, sorry.
In an existential way. How is it a good thing to remove the road improvement?
like I said, we have to make the decision based off what we have today and the rules that we have to follow, so I can't really answer that question. If it's good or bad, that depends on,
No,
person
what?
individually. So I guess I will close public comment. Oh, sure. I'll take two more. I saw two hands, so the last two comments before we close public input.
Yeah, my name is Bill Landers. I'm not concerned about the building. I don't care about the building. We don't want the cannabis growing there. That's our argument that we've been arguing the whole time. And what, now they want to put a building up there, go ahead, put a building up there. Don't want the cannabis grow there. We don't want the traffic. We don't want the people coming up through there. That's our argument, and that's what we're sticking with. So hopefully you get that. Thank you.
I want to make sure Joni Henderson. I want to make sure we're properly applying here Public Resource Code 1270.2C3. I believe that affected activities include application use permits. This is a use permit. It puts it right back under 4290. Please, I do think it does. I think it kicks it right back, regardless of the building. It's a new major use permit that's being applied for.
Thank you. So I will be closing public input, public comment for this item. I will bring it back to the commission for any further questions to staff, to clarify any, questions that you guys might have to make your final determination.
I have a question for council in regard to comments that were made earlier in regard to the homeschool. There was a comment made that the Planning Commission has authority to improve the standards of the county code. Can you respond?
That is inaccurate. Your commission does not have authority to change ordinances at all. You do have a little bit of flexibility in conditions attached to permits, which relate to the findings you have to make for a particular permit approval. So if there are certain things that prevent you from making a finding, one of those listed findings, I don't know if you're provided a copy of them during hearings. If you'd like, I could pull them up, or staff can pull them up and we can read them to you. But under those findings, if there's something in the record that's presented to you that doesn't allow you to make those findings, and you think there is some alteration to the project or condition that might allow you to make those findings, then you can propose that. But you are not empowered to change either state or county ordinances. And in relation to schools, the rules are that, yes, the California Business and Professions Code does provide a 600-foot setback in section 26054, part B, for commercial cannabis cultivations, and it does not list a definition for schools there. However, in that code section, it does cite that measuring distance will be measured the same way as in the Health and Safety Code section 11362.768. And in that section, it says, for the purpose of measurement, schools shall be defined, and this is in Part H of that section, in the way that I had read to you earlier. That was exact. Part H was what I read to you. Schools will be defined for measurement in both Health and Safety Code section setbacks and the Business and Profession Code setbacks in the way that was read, which would exclude schooling that was held entirely in a private home.
I think this issue is cloudy.
Could you clarify what our choices are now that are in front of us? We've got A, B, C, or how many do we have? And as far as we vote yes, we vote no, we vote maybe, where are we?
So the commission has, as always, the option here of adopting the recommendations provided by staff in wholesale. That would include the requirement to meet 4290 and 4291 standards, whatever that would apply on its face in those code sections, and not having a setback for the school. And any setbacks adopted for the school, if your commission would like any, would have to be based on the findings and not on this specific preference. I mean, it would have to be something unique to this project that would prevent you from making those findings. The fact that it is a school and you would rather there not be cannabis near a school, I don't think meets that standard. There would have to be something specific that violated the findings listed that you must find. Because there is not a rule that allows you to require a setback for schools as defined, including private home schools. So it would have to be something unique and not general that would apply here. You would have, so those two things would apply. The setback would not be required, and 4290 and 4291 in its entirety would apply to the project roads. If you can also adopt the recommendations of staff with amendments. And this is where you may, if you do have changes to propose, you may propose those, and those may be adopted as part of your decision. Or as a final decision, you may just deny the project in its entirety. As an ancillary, you do have the option if you want clarifications from staff, if you want, if changes that you request require further actions, like if it requires further analysis under CEQA or some other kind of information, you may also continue. You do have an option related to 4290 and 4291 if your preference is not to exclude, if you're not going to ask the applicant to exclude the processing facility, and 4290 and 4291 would be applied, then the applicant would also then have under, I think it's Title 14, Division 1.4, Chapter 7, Subchapter 2, Article 2, Section 1270.07, exceptions, would have the option of applying for an exception to 4290, 4291, which would allow them to keep both the processing facility and the cultivation. But what they would do then is request an exception from 4290 and 4291, which would allow them to apply equivalent but different standards, which would allow for fire safety and the project to proceed. But that would require the applicant to apply. The rule requires the applicant to apply for the exception.
Thank you.
All right, so we always get these, well, not always, very rarely we get projects like this where, a project comes to a community and the community, doesn't feel like it fits there. Could be true. It is true. It's, it just depends on which side of the aisle you're on, I guess. But again, our decision has to be made based off what we have here on paper, either by the changes that were recently made. We can't, as much as we would like to, take into consideration the school, because that seems like it's one of the main things that has, one of the main issues that has been brought up, in the roads. But we just can't use that here with the we have to make certain findings, and we can't exclude certain reasons or certain. Yeah, it's tough. But if you guys have any changes or any requests that you guys would like to see, or a final thought before we take a vote? I
just want to express how I feel about this. I I see a lot of cloudiness. I think some of the road improvements should happen anyway. I don't know how to make that happen, but I'm concerned about it. I'm concerned about the water, the school. Is it a school in a private home, or is it in a garden, a farm? The fire safety is huge. So what I do when, we're a quasi-judicial body, as I understand it. We're not legislative. We can't make rules. We have to interpret them. So the way I interpret the rules is I kind of use this, and I'm sure you guys have heard me say this before, your right to swing your fist ends where your neighbor's nose begins. And I see some noses that are in the way, so I don't think I can support this project.
Okay, I still have concerns about the road. This is a very high hazard severity zone, fire zone. Regardless of what kind of project it is at the end of the road there, the road is not in good shape. And this is from testimony that has occurred in various different hearings. Again, I go back to, as far as clarity, as I do agree with the comment that is in one of our green sheets, that previously the applicant was told that PRC codes 4290 and 4291 apply to interior roadway improvements on the project parcels themselves. So with that being said, this would only require interior roadway improvements on the project parcel. I have a different interpretation of that. This roadway has many issues that, in my mind, need to be addressed for the public safety and the health and well-being of the community and the fire zone. So I would, my feeling at this point is either moving towards denial or moving towards continuance with more detail. I don't think it's good enough in our report to just put that the project will comply with 4290 and 4291. I think in this particular case, given the severity of the situation and the road, that there needs to be more specifics in regard to exactly what will happen with that road situation. Thank you.
So do we need to start with a motion? Can we do that?
We could do that, yes. Yes, we could take a motion, or if you wanted to discuss further, or whichever.
I want to just echo, I have similar concerns that both my commissioners on either side of me have expressed. So I would like to move that at this point in time, we deny the application of this permit.
I would second that.
We have a motion and a second. All in favor to deny?
Aye.
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 All opposed? I'll say aye on this one. So the motion to deny the project passes with 3 ayes and 1 nay. Is there anything else that we have to say on the?
Just read the 7-day appeal.
Very well. So the motion passes. Note, the applicant or any interested person is reminded that the zoning ordinance provides for a 7-calendar-day appeal period. If there is disagreement with the Planning Commission's decision, an appeal to the Board of Supervisors may be filed. The appropriate forms and applicable fee must be submitted prior to 5 p.m. on or before the 7th calendar day following the Planning Commission's final determination. All right, thank you very much. Does staff need a longer break? 5? I'm gonna say 10. So we're gonna take a 10-minute break. It is 11:28. We will come back at 11:38. Thank you. Check, check. All right, I am showing a time of 11:38 after our 10-minute recess. Call meeting back to order. And we are moving on to item 6B, our 9:20 a.m. Public hearing consideration of deviation DV 24-01 to allow a reduction in road standards improvements of an existing minor road. The applicant is Alexander Johnson. Location is 9100 Rocky Creek Road in Lower Lake, APN 122-251-08.
Chair Chavez?
Yes.
I would like to request a continuance of this item to a future meeting. We do anticipate a number of these projects coming forward to the Planning Commission in the future, and there are a few details we'd still like to further clarify in our staff memorandum.
Okay. And it'll just to a date uncertain?
Date uncertain, please. We'll
All right, can I get a motion?
Re-advertise.
Someone's up. Second.
All right, we have a motion to move DV 24-01 to a date uncertain. And all in favor?
Aye.
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 All opposed? None. And the motion passes to move this item. Moving on to our next item. Item 6C. Consideration of Director's recommendation of revocation of major use permit UP 20-50 Pillsbury Family Farms located at 26102 19 North 16 Road, Lake Pillsbury. APN is 001-030-36. And we have staff.
Thank you. Mireya Turner, Community Development Director. What you have before you today is a director's request for a revocation of major use permit UP 20-50 for Lake Pillsbury Family Farms. The revocation is based on two criteria. One is cultivation without a state license in 2022. The second is one of the permittees' inabilities to qualify for through the background check, to successfully pass a background check. As this commission is aware, by county code and state law, dual licensing is required. That means the county permittee must have both a county permit as well as a state license for operation. On May 26th, 2020, this department did receive an application for major use permit UP 20-50 for outdoor cultivation. Almost 2 years later, January 27th, 2022, that permit application was approved by the Planning Commission. So in between that time, there are a few steps. I just want to refresh the commissioner's understanding. When we receive an application, we enter into the completeness step. That's to make sure that we have all the information that we need in order to process that application. We have 30 days to complete this completeness step, and then we go into the actual processing of the permit, which is sending it out for agency and stakeholder review, doing our internal review, our environmental analysis, gathering the recommendations from the agency review, analyzing those, and then finally assembling the conditions of approval and taking the permit application to hearing. It takes time. So January 27th, 2022, the county did approve major use permit UP 2050. Later that year, August 16th, 2022, the state license was considered complete. So that's when they would start their license processing process. About almost 2 months later, we did an annual site monitoring, or annual compliance site monitoring visit. And there was active cultivation taking place. It wasn't until July of the next year, so about 9 months later, the state license was issued. Article 27 does include a possibility to move forward, that the county would consider their permit active if the state has a delay in their process. This is because back around that time when this ordinance came into effect, the state was saying, we're having a delay because we have way too many applications. We're bumping up our staff in order to, meet this need. And so there is this delay aspect saying, should there be a delay in the state's issuance of a state cannabis cultivation license, which delay is solely caused by the state, the applicant may be granted a minor or major use permit if all other applicable state permits have been attained. This department, I do not consider normal processing time for a permit to be a delay solely attributed to the state. The state received, according to our timeline, the state received a complete application. That means that the fees were paid. There might have been all sorts of materials submitted before, but as you see in the attachment to the staff report, the state does not consider an application complete and therefore does not even start their evaluation of that application until the fees are paid, which was done August 16th, 2022. So I did not consider that a delay. It was a normal processing time. In fact, they processed theirs faster than we processed ours. The second reason for the revocation request is a failure to pass a background check. According to county code, all applicants and employees shall undergo a background check. As included as attachments in the staff report on May 20th, 2020, July 26th, 2020, and May 10th, 2024, documents filed with the Secretary of State of California listed Justin Quayle as a CFO, so Chief Financial Officer, Manager, and Director. The background check process, according to county code, is required by county code, goes as follows. The applicant submits a live scan form to the sheriff's office. They then distribute, or they send that out to the Department of Justice and Homeland Security for their review. Those two agencies send back any reports of a criminal record or any record. That list is then evaluated by the sheriff's office. They do not release those reports back from those two agencies, but they do review them. They look at a set of criteria that was also included as an attachment to your staff report that for various disqualifying criteria. They then send community development a one-page report of whether or not that applicant is qualified to participate in a cannabis-related business or is disqualified. They don't tell us why. That's just a one-pager that we then store in our records. I was doing a project review for this permit, and I found background check reports qualified for John Evans and Skyla Lewa, who are the two other members of this permit. I could not find a background report from the sheriff's office on Justin Quayle. So we then sent an inquiry to the sheriff's office saying, would you please check and see if you have any record of a background check for Justin Quayle? They searched their records focusing on the time when the other two applicants had submitted theirs, a month ahead and a month behind, and found no record of any background check application for Mr. Quayle. That's when I drafted the notice of intent to request or to recommend a revocation letter and sent it to the permittees and their representatives at the time, noting that I was going to recommend revocation due to cannabis cultivation in 2022 without a state license and the lack of background check for Mr. Quayle, since that is a condition of their approval for major use permit UP 2050, that all employees and permittees successfully pass that background check. That letter was dated April 9th, 2024. April 12th, 2024, the Sheriff's Office received an application from Mr. Quayle for a live scan background check. Later on in July, we received a notification from the Sheriff's Office disqualifying Mr. Quayle from participating in cannabis-related business permits. Through subsequent email and in-person communications with Mr. Quayle, he let us. He wanted to know why he was disqualified. CDD is not able to tell him that, so I referred him to the Sheriff's Office to figure out why. Additionally, any possible reversal or anything like that from that disqualification would have to be done through the Sheriff's Office. So I communicated that with him as well. Mr. Quayle let us know that he had hired an attorney to work with the Sheriff's Office regarding that disqualification, and so that is why there is a delay from July of last year till today of having a hearing, because I wanted to give him appropriate time to be able to work with the Sheriff's Office in case there was an opportunity for that disqualification to be reversed. So then a few months ago, I received a notification from a new representative for Pillsbury Family Farms demanding that their permit go before a hearing so that they could talk about it. And that's why we scheduled the hearing before you today. That concludes my presentation, but I welcome any questions the commission may have.
Thank you, Director. So, is there any questions regarding the?
Seems pretty cut and dried to me, but I'd like to hear any public comment. The only thing I've seen in public comment was a very well-written letter that from Skyla Laiva. Thank you.
All right, seeing as we have no questions from the commission, I'll open it up to public input. If you guys would like to speak, you will have 3 minutes. Just state your first and last name.
Is this the only time that we have to actually defend these allegations against our farm? Or is this just my public comment?
Well, this will be public comment, and then we'll bring it back to the commission for action.
Okay.
Or
like the last guy had 20 minutes to defend his.
well, you guys will get public input, so you guys can all speak if you guys would like.
Okay.
So.
My name is Skyla Lewa. I am the Secretary of Pillsbury Family Farms. I also do our IT, farm management, metric compliance, and county liaison. When we applied, we came before this board on January 27th of 2022, and Mr. Chavez was one of 2 of the commissioners that was on this board that approved our project. That project was passed by Mary Darby, the previous administrative director before Maria Turner, and in her specific staff report, she said all 3 of us, Justin, John, and me, passed the background disqualification. I would like to note that on Ms. Turner's staff agenda, a memo, in her attachment from the Sheriff's Office, it does state down at the bottom that an applicant, once they pass, their background disqualification gets passed, they do not have to go and rerun their fingerprints again. My license is not in the process of being suspended. My county permit is not in the process of being expired. It is still valid until 2027. And it is not being revoked. We are in the process of this recommendation of revocation by Ms. Turner right now. The reason why was because Mr. Quayle wanted to show compliancy with the county, and so he said, okay, you can't find it, I will willingly go and get it done. Mr. Quayle did that. We have passed the state background check for all 3 of us. Mr. Quayle is on our state license. He still holds his state license. The state has not came back and said, Mr. Quayle, you have a disqualification. Since being issued our state license, we have maintained compliancy. We have paid our dues. We are ahead of the game. I would like to bring up the fact in the most recent task force, Maria Turner brought up the fact that, Water Board, the property owner, Mr. Evans, needs to be on there. We did that. Mr. Evans needs to be on the application prior to the new rules that were implemented. We did that. Mr. Evans was the applicant that submitted it because that was the requirements then for the county. Since then, we have maintained compliance. We have Tiger Metric. Last summer, we had PG&E fly over, which they assist the sheriff's department in revocating all of the illegal grows, which we had one on our farm, and so they flew the whole entire thing, and it was a PTSD moment for Mr. Quayle. Mr. Quayle has been through a lot in his cannabis history, as well as Mr. Evans. Mr. Evans has been on the property since the early 90s. Mr. Evans qualifies as a legacy cannabis grower by county ordinance standards. He was arrested in 2015 for illegally growing cultivation on his property. He has gone through the right remedies. Mr. Quayle has also taken it upon himself to exercise his rights under California Penal Code 1203.4, which allows for the expungement of his record. Mr. Quayle is in that process, and I know Mr. Quayle has asked me not to, but I just really wanted to point out that we are the most transparent and compliant farm that this county has, and our transparency and honesty is being weaponized against us. Muleham.
Perfect timing. Well, thank you for speaking and defending your farm. We have another public input.
Yeah.
First and last name for the record.
John Phillips, Chairperson, members of the Planning Commission, County Council. Let us ground this proceeding in reason and law. For the county's revocation effort against Pillsbury Family Farms violates not only statutes, but the very principles of equitable governance. This action is not a measured exercise of authority. It is an erosion of rights cloaked in procedural pretense. The facts are unambiguous. Under the Permit Streamlining Act, deemed approval becomes irrevocable once statutory deadlines lapse. To retroactively impose new conditions now is to reject the finality the law provides, a finality essential to the trust between citizens and their government. You cannot unmake what time and compliance have rightfully cemented. Conditional use permits adhere to land, not individuals, and for sound reason. They ensure stability in zoning, predictability for communities, and fidelity to long-term planning goals. To tether permits to owners rather than to property invites chaos, permit shifting like sand. With each sale, zoning rendered meaningless, and communities subjected to the whims of transient interests. The law exists to prevent such arbitrariness, yet you court it. Your use of criminal background checks as a permit condition betrays this purpose. Land use authority concerns itself with property impacts, traffic, and environmental effects, compatibility with zoning. Diverting that power to scrutinize personal histories unrelated to the land's use perverts the law's intent. Title VII's protections against disparate impact of California's Ban the Box statutes, AB 1008, recognize this fundamental truth. When policies burden protected classes under the guise of necessity, they fail both justice and logic. The county's own 2022 staff report confirmed Pillsbury's full compliance. 3 years later, you offer no new evidence, only recycled allegations. Under Motor Vehicle Manufacturers Association v. State Farm, agencies must base decisions on reason analysis, not conjecture. Where is the fresh proof justifying revocation? It does not exist. Nor can your reliance on local ordinances 3073 and 3079 stand. These provisions cite cannabis laws.
Those are your 3 minutes, but if you want to wrap it up, I can give you an extra 1 minute.
Thank you. Justin, would you yield your time to me?
Go ahead.
Or John?
disability anyway, so they're gonna have to, it's gonna take them a while.
John, would you yield me a minute?
Give him a minute, your speak time.
Yeah.
Thank you. Is that good? Couple minutes?
Yeah, so, yeah, we'll do the 6 minutes.
I have an ADA.
Or, sorry, an extra 3.
Okay. Local ordinances 3073 and 3079. These provisions cite cannabis laws repealed by MacUrsa, a statutory framework dissolved by the legislature's own hand. To enforce them now is to govern by shadow, reviving invalid laws to punish lawful conduct. Let me repeat that. To enforce them now is to govern by shadow, reviving invalid laws to punish lawful conduct. City of Riverside v. Empire or Inland Empire Patients forbids such overreach. Yet here we stand, watching the county wield dead statutes as weapons. If this commission revokes the permit today, you ignite inevitable litigation. Regulatory takings claims under Lucas v. South Carolina Coastal Council will follow. For the law does not tolerate retroactive destruction of vested rights without just compensation. The county's liability will be as certain as it is avoidable. To the Planning Commission, your oath binds you to the law, not to the county's overreach. Personal views must yield to legal duty. Reject this revocation. Demand ordinances reformed to align with state law. And to the county, mark this. I want to make myself crystal clear. Every due process violation, every reliance on defunct statutes, every deviation from evidence will be contested without relent. We will litigate each error until justice prevails. Pillsbury Farms operated within the law's bounds. We will defend it with the vigor the law demands and the county's actions invite. The choice is stark but simple. Withdraw this unlawful proceeding, or let the courts reaffirm the foundations of ordered liberty. The law is not clay to be molded to power's will. Heed its true shape. Currently, there are only 125 active state licenses in this county. This is what remains. 1,200 over the last 8 years. Quickly to the point, this is the most important part of this hearing today. Pillsbury Family Farms has an active state license. It won't expire until next year, January 1st. They have had it for nearly 2 years. Mr. Quell, in fact, passed a background check in order to receive said license. Thank you.
Thank you.
I have
State your first and last name for the record.
My name is Justin A. Quayle. I was born with a disability, so you're gonna have to hang with me. I don't read very well. I'm dyslexic. But I do want to say one thing. Mary Darby did a disclosure over the phone the right way. Okay? I have emails that have gone to her, the sheriff's department, and yes, I am in contact with the sheriff's department. I got a police report yesterday, and they finally took the charges. Thank God. You know, the DOJ, great people. They told me what was going on was illegal. Not good. You can't oversee the DOJ. My uncle, Dan Quayle, he kept himself around people with disabilities because we care about people. I don't just care about people, I care about my community that I grew up in. My mom worked for this county for over, 28 years. I worked for the Mendenhalls. I'm not proud of my past of it, But you know what? I go to counseling still, to this day as an adult, for my past, and I will never stop for somebody that experience that we're all talking about. Luckily, next month, we'll get it expunged the legal way. We talked to the sheriff's department. I was right. She is extorting me pretty much to keep my license. I have receipts from 2019 for the live scans I did. I also did a hemp live scan and passed. The nice lady down there, oh, man, this is a bad disability. Well, anyway, the lady down here at the hemp thing, she's awesome. Keep her forever, please. She said I passed during that time and I would be able to work on a cannabis farm. I've worked for Flocana. I passed their live scan, and there was, you want to talk about live bad, they made me do disclosures. I had to get a lawyer named Omar Figueroa to help me pass through those disclosures, and we got it. You know who is also, his name, he's the director of James Eubanks, from the director of Department of Vocational Rehab. Awesome man. He helped me get my job at Flocana. He helped me get my job at another distribution down in Sonoma County. He also helped me get a job. I'm sorry about your beeper, but you know, this is my life here. You're my dream.
We'll give you another minute to close your statements.
Okay. Well, can I read my thing? It might take me a while, but I'll read it. We don't have Braille anymore, so when I was forced, they made me.
Go ahead.
I can't.
Would you like me to read it for you?
Yes, please. No, I think it's all of it.
Okay, so we have.
I had problems uploading and downloading things.
So this document has been submitted to us already, so we've already read it.
Because I did.
Good job. Thank you.
Thank you.
It was the same one, right? Okay. All right. Thank you very much for your comment. Does anybody else wish to speak? Can we take a look in the Zoom room?
No hands are up.
No hands in the Zoom room. Looks like no hands in the chambers. And I'm going to close public input and bring it back to the commission.
There's Donna from Redwood.
Oh, Donna, I'm going to open public input for you.
Thank you. Donna Mackwitz from Clear Lake Oaks. I thank CDD's careful review of this project and hope the commission respects their findings. The previous speaker and employee said that they're the most transparent cannabis farm in the county. If you've not viewed Mr. Quayle's Facebook posts, you might want to. I find they're kind of disrespectful and very unprofessional. Thank you.
Thank you for your comment. Public input is now closed.
There are a couple.
Oh, all right. We're getting some more hands up on Zoom room, so we'll keep the public input open for a couple more hands.
Okay, a guest from Samsung.
Samsung. State your first and last name for the record.
Cameron Hodges.
There we go. I think we can hear you. State your name, your first and last name one more time.
Yes, Cameron Hodges.
All right, you have 3 minutes.
You hear me?
Yes. We can hear you. You have 3 minutes if you wish to give a public input on this item.
Yeah, are you able to hear me?
Yes, we can hear you.
Okay. So, yeah, my name's Cameron Hodges, and I am a breeder. I work in, I make strains for Pillsbury Family Farms and many other. I've been breeding for about 15 years, and I work with operators in counties all over the state and in other states. And I got to say, these guys are really, really on the books. Like, there's a lot of very shady operators in this industry, and these guys are these guys have been absolutely good. His word has always been gold. He's always, you know what I mean? He's it's pretty rare to find somebody with actual good moral and character like these people, and it's a pretty brutal industry. And especially if you were to compare Oklahoma, it's 1 cent per kilowatt with no income tax, $3,000 for, you can grow all you want there. So when you juxtapose that to all the regulations that they have in California, it just seems really hard to compete, and it shouldn't be cheaper for someone to grow inside somewhere else than it is to use the sunshine in California. So I would just say that you guys would want to maybe recognize when you have a good, honest operator and treasure them and be their ally and do what you can to help them, because they will bring in a lot of tax revenues for you over time, and you live in a special climate where you really need to take advantage of the outdoor climate that you have there. And you have, this guy is kind of a local legend. He really knows what he's doing. He keeps his word, and he produces some of the best. So it would be a real shame for you guys not to protect these guys. They've been really good to the community. They've been good to me, and they will definitely, as far as reputation goes, you need this guy to build your county's reputation. It's pretty much essential that you protect these people. Thank you very much.
Thank you for your comment. I think we had a couple other hands in the Zoom room. No more? Okay. Seeing as there are no more hands in the Zoom room and everyone in the chambers already spoke, I'll close public input now and bring it back to the commission for questions or concerns or action.
First of all, I just want to thank you all for coming. I hear you. We are not a legislative body. That means that we can't write laws. We just interpret them. So if we follow the recommendations of staff, we're not against you. But we need to have the paper in front of us that is required by law in order to approve anything. So I guess what I'm saying is I'd really like to see your operation succeed. But without the Sheriff's Department document, we can't do it. So I cannot do anything today in good conscience, despite the fact that I would really like you to succeed, until that happens.
Public input is closed, but we're going to see if there's any other questions, and potentially I might open it up if there's any questions from the board to you guys, to the applicant.
I just have a question. You say that the process, I'm not sure if I'm saying it right, the revocation of your legal status is in process of being reclassified?
She just didn't give us enough time. It takes a year and 13 months up to...
Excuse me, if you'd like to answer the question, I want to ask you to come up to the podium.
So you're reopening?
Oh, I'm
No,
sorry.
she's
Is that
asking a question.
reopening public comment?
Would that constitute opening
The law that,
public
when
comment?
I went to go get
Can you give me 1 second real quick?
Okay. I'm not sure who I was asking the question to, but it was just a question,
If we're going to have the...
It's up to the chair as to how a meeting is run. In the past, the chairs have invited applicants and their representatives to sit up here and comment and reply to questions. In the more recent past, the chairs have decided that the applicants will comment in the comment period. It really is up to how the chair chooses to run the meeting. I will say, however, that if you do provide extra time to the public, to some members of the public, that you provide that same time to all of the members of the public.
Okay, so if we open up, or if I allow the applicants to answer questions from the board, without opening to the public? 'Cause they are the applicant?
Yeah, you need not open comment to the public if you're going through the application or the applicant's, yeah.
Okay, so if it's a question directly to the applicant, I don't have to open up public comment?
I don't think so.
Okay, very well. All right, there was a question for me?
I just I wanted to know, what is the timeline in your process for getting your status reclassified?
The lawyer that we hired to do that said that it was going to be up to a year, but we have a court date next month.
Oh, could you get closer to the mic?
Okay.
The lawyer that we hired, he said that it could take up to a year, depending, but he's working on one county at a time. The only one that's disqualifying, but I'm trying to get everything done. You know what I mean? Everything all the way back from the 90s. Even if it was a misdemeanor, I'm trying to get expunged. So,
So you were talking about you're trying to get your record expunged so that this would not exist, or
Yes,
that
yes,
you would be
yes.
approved.
yes,
Sheriff's
yes,
Department.
that's the one yes.
Okay.
And yes, I'm going to answer, go ahead. Ask you.
I just wanted to know where you were in the process.
We have one court date left. I've already got the thing from the DA, and the probation department has recommended, they're going to recommend removal. So I have a court date in less than 10 days. So if we could put this off for, another month, at least you'll have that, because then they have to rerun it, the sheriff's department. According to the sheriff's department, he said that he would have to rerun it. He doesn't think that I should even be going, that there should be a way for my company to have me step down. That's the legal way, but nobody gave us that option. We asked, but they said we're not allowed to do it. But the legal way is for me to step down while this process is going and allow my business to keep going. If we're going to go down this route, I think that every applicant, every sheriff that comes in should have to reapply, honestly. Because the sheriff said every sheriff has a different determination of the thing. Mine's called a wobbler. I'm not sure. But in Sonoma County, a wobbler does not take your license away. It will make you step down while your business stays open until that's cleared up, or I have to be removed permanently. But that was never an option. Another option in Sonoma County, even in this county, is to allow you to step back for a year, shut your business down, and follow, something like that. I don't know the exact words. So we were never given that option. And then also, while I was talking to the DOJ, they have proof that I got a live scan. And the district attorney can get that. And we went up to the district attorney's office and they said that it was a misuse of power that she's doing to our business, because there is a legal way to keep this business open and keep going. And that's why I wanted to make sure, because you guys are also part of the responsibility if you do it, because there is legal procedures on how a background check is handled. Period. So, when, and the biggest complaint, I know we don't want to talk about this, but she disclosed all my personal information. Not just once. This is several times. The information you give to the sheriff is private. Okay, my social security number should have never been shared around this office. It should have never been posted on the board here.
I think the only thing that we received was
Thank you.
just,
I just needed to know.
Okay, no problem.
Thank you very much.
Yeah, no problem. Any questions?
Oh, yeah. I think she wanted to say something real quick.
Just to remind you, we are a C corporation. We are a legal entity, and John Evans is the CEO, and he holds 50% of the power, and I only hold 10. And we have rights in our bylaws that we can hold a special meeting and we can remove any one of our officers at any time for any reason. And so for this background disqualification on one particular member of our operation should not be grounds to shut the whole entire business down. Yes, Mr. Quayle is right. We did ask Ms. Turner if we were allowed to do an opt-out of cultivation for this year, and Mrs. Turner's response was that it is not possible because she is trying to say that without Justin Quayle, our company cannot operate. And I am here to inform you guys that if we, the board, this modification as an option, as a solution to this situation, we're willing to modify and ask him to step down until he gets his background disqualification clear. I don't know if that is acceptable for Ms. Turner because she said it wasn't optional. If a reduction of cannabis isn't optional in this board and our previous board of supervisors passed a resolution to allow that to be an option, then we as cannabis permittees should be allowed to take the available options that are legally available to us, which is the reduction of canopy, opt out of cultivation for a year, or fallow. We have asked these available options if we can use them, and we were told no because Mr. Quayle is an integral part of our business operation, and I am here to tell you that he is not. He is indispensable at any given moment, and it's not permanent. And I would also like to point out that the Department of Cannabis Control also has a section in their rules and regulations to allow a license modification of an owner to step down. Thank you.
Okay, very good. Thank you.
So a question from one of you, as long as you're talking to us. So do you have a commercial cannabis cultivation state license?
Yes, it is CCL 22-0001641.
And it expires when?
It expires on January 1st of 2026.
Mm-hmm. Thank you.
We're gonna wait until there's a question. Yeah. All right. You have a comment?
Yes, I think that this is a legislative issue, and I really think it's wonderful to have this kind of vocational opportunity. And I really encourage you to get the paperwork done so that we can approve it, because I can't. We have to revoke it because there is no, I mean, that's my feeling. The other commissioners might disagree with me, but what I'm seeing is that there's a piece of paper missing here. And I am not the person to write the law or to evaluate whether you should have that piece of paper or not. I'm here to judge whether there's that piece of paper here or not, and it's not here. So I really appreciate you coming in and helping me understand what's going on here, and I heartily encourage you to get the paperwork done, whatever's needed, so that we can keep this very valuable business going.
So in that case, would we allow the applicant more time to figure out what paperwork needs to be done, or what kind of
What are our options?
what their options are to either remove their member for the time being, or
I don't think we can tell them how to run their business.
well, we can.
Can we do a continuance?
Yeah, do we give them time to do that?
I'd like to hear staff's opinion on that.
So, and I
don't
also
know.
have a question in regard to the reports, the inspection reports that were done, and this is kind of new to me, but with the inspection reports that were done, is I'm reading through them and reading that they were somewhat favorable. There was a few. So anyway, I would just like some information from staff in regard to the reports and kind of how they rate, so to speak, on a scale of 1 to 10, or how those inspection reports that are included in our information that we're reviewing here, how they measure up, I guess.
Thank you. Article 60, revocation of permits can be based on that one or more of the terms or conditions upon which the permit was granted have been violated. Cultivating without a state license in 2022 is a violation of those conditions. Not satisfying the background check for the county is a violation of those conditions. throughout the entire life of this permit, Mr. Quayle has been a primary representative because he's the main cultivator of the permit. He's been listed as farm manager. He's always been the one that we've talked to, and as well as Skyla. Were they to withdraw his participation in the LLC through the Secretary of State, I suppose that would satisfy a paperwork of saying he would no longer be part of it. It would not, they're currently cultivating in violation of both of those conditions. So were one to be removed, it would remove one of the two reasons for my request for revocation. If they were allowed to continue cultivating right now, I have no authority to say, yeah, go ahead and cultivate while you go get this stuff worked out. I have no assurance that, one, it will get worked out, and two, that the sheriff's office report will reverse. I just don't have that authority.
So I hear you both, and I encourage you not to be angry at the bureaucrats here who are charged with enforcing what they feel are the regulations. This is one of those difficult situations where you got to dot your I's and cross your T's. If you're currently licensed by the state, that's great, but I'm still not seeing that one piece of paper.
I have a question. Then why would Darby have me do an open disclosure over the phone?
Could you come up to the podium if you wish to?
The question was why the prior...
Yes, why would we did a disclosure over the phone with her, and she said she went, and we had so many troubles with her because she had to go through our whole entire file again because Miss Ham put it on her desk off to the side. And so when Miss Ham lost our folder, and then we go all the way back, I know she misplaced it for a year on her desk. I know it's horrible. But it happens, you know, you lose things.
Just so you understand, I'm an organic farmer as well, and I understand that bureaucracy is a pain in the...
It is, but
we got to do it.
At least I did everything legally right to get approved the first time. Regardless, it got lost again, and this is a problem with the county. There's a file, there's an attachment there on the original file that you guys approved that was there. It was there because Darby contested to it to you guys.
Well, you need to find it and bring it back to us.
Right, and obviously it hasn't been found, but obviously that I've been doing everything correctly from the gate. And so you do have the power of pushing it on and waiting for my hearing. You do have the power to say, hey, we need to check in a month and make sure this is going. You do have the power, because it's not a violent crime, to keep going. If it was a violent crime, I would have been denied completely, and our whole entire project would have been shut down, according to the DCC. The DCC had me do disclosures twice, once for Miss Ham and once for Eric Porter. When we did all the disclosures with Ham, we did them legally. I don't know what happened.
Okay, we're going to bring it back to the commission, and...
Thank you very much for your input. I do not have the power to do anything except revoke this today. That's my interpretation of the law.
I guess the question would be for the director. So I understand that we have these two items, or these two things that need to be fixed. One cannot be fixed. Is that correct? The 2022 cultivation. And then the other one potentially could be fixed about the background check. But
any cultivation taking place right now is in violation of their conditions of approval.
Okay. Yeah, so I mean, we can't...
Well, if I could also just refresh go back and cover. When I performed my own review, because I cannot speak to previous directors, one of the conditions upon approval was that all members pass the background check. When I went back through the project to do the review, I found no record in either our digital or our paper records of Mr. Quayle's qualification report from the sheriff's office. We then placed a request for the sheriff's office to review their records of all applications that they have received. They found no record of a background check from Mr. Quayle. That is why I sent the letter of intent, or the notice of intent, listing both cultivation without a state license in 2022 and no record of completion of the background check for Mr. Quayle. At any time since the date of that letter, which I think was April of 2020, I forget the date, but it's on your staff report. Anytime after that, Mr. Quayle was free to give us his evidence of a successful qualification or passing of that background check. No such information was ever received by our office. I was giving him time to work on that. It was only after I started receiving emails questioning the veracity of consulting with the sheriff, and then Mr. Phillips as representative for Pillsbury Family Farms demanding a hearing, that I brought this to you today. He has had, since that notice of intent letter, to resolve the matter.
You see that Ms. Turner is working to get you through this. She's trying to help you.
Why is the tax collector saying that you part of this?
I have no idea why about any of the other stuff. All I know is I've read all this material in front of me, and I'm ready to make a motion until as soon as the other commissioners are finished discussing it.
If you would like to make a motion.
I move that we revoke the major use permit UP 2050 for outdoor cannabis cultivation of up to 110,000 square feet located at 26102 19 North 16 Road, Lake Pillsbury, APN number 001-030-36, due to cultivation without a state license in 2022 and background check disqualification of permittee Justin Quayle.
Do I have a second?
Second.
All right, the motion's in place. All in favor?
Aye.
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 Aye. All opposed? Motion passes.
I forgot to note in the staff report, but there is a 7-day appeal period of this decision to the Board of Supervisors.
Where is it?
Also, Chair, we've reached 12:30, which is usually when we need to break for lunch. We have a discussion regarding billboards and department update left. Would you like to break for lunch?
I'd like to just get her done. I think that the item about billboards will just take a couple minutes.
Up to the chair.
Yeah, we can continue.
Double overtime.
All right, so moving on to our 9 timed items. Also, I couldn't find the note for the item that we just went over, 6C, about the Board of Supervisors. Do I have to read it, right?
I actually did it for you.
Okay, all right. Just
They
making
said
sure.
they're on their way upstairs to get that appeal form, so I think they got the message.
All right, just making sure. All right, so moving on to our non-timed item 7A, discussion regarding off-site outdoor advertising billboards, regulations, and current permits, and consideration of recommendation to Board of Supervisors regarding off-site outdoor advertising.
So I've been thinking about this, and I'm wondering, where are we in the general plan process? And is this something that would be better addressed by that, the 2050
Thank you. We are currently in the drafting of the local area plans and the countywide elements. Just as a side note, already in the Middletown local area plan is a discouragement of further billboards. We do anticipate that those draft documents will come down or will be available for public review in July, August, sometime late summer, early fall.
I think that's a better place for this. I don't know about anyone else. But.
I would agree. I was going to make that same suggestion.
Me too. I was certainly surprised how many regulations there are. Can't just put up a sign.
No.
All right, and I believe that was it for item 7A.
Thank you. We will make note of that as we move forward with the Lake County 2050 process.
Thank you. And department update?
Thank you. I just have one item today. I was notified by IT that the planning commissioners' emails have been inactive for so long that some of them have been expired. I just wanted to encourage you, yeah, you're hiding your face, I see that, Miley. I would encourage you to use those because those are your public email addresses, and to separate, to clearly delineate your personal email correspondence and your public is in your own best interest should we have a public record act request. I really don't want to dig into your Gmail accounts. So we're going to work with IT to get those reactivated and used for each one of you. Also, as a side note, should you sometimes get constituent emails sent to your personal address, please make sure that you route it over to your planning commissioner email address for your own convenience. That's all. That concludes my update. Oh, but County Council might have more.
So what is the projected timeline on that?
I will contact them today.
Okay. So in activation, I mean, it should be somewhat.
I already let them know
and
I was
then-
going to lecture y'all severely, and we should expect those emails to get reactivated soon. So
Okay. And so then there will be also some instruction about how to
absolutely,
use them?
yeah, we'll make sure you've got your password set up and all that stuff.
Okay, great, thank you.
I want to reiterate using the county email. It will make it easier for county counsel's office to contact you for things. If there's advice I have to give separate from outside of a commission meeting, attorney-client privilege communications, I'd prefer that those occur on your county email rather than a private email address.
And we also do have ways that we can connect to your county email, like you can upload it to your phone so that you get those notifications and you don't always have to go check on your computer. That concludes my department update.
I just have a question on future things that'll come to us. I saw in the newspaper, I think it was in your report to the Board of Supervisors, that the draft cannabis ordinance was going to come to us in April. April's like next week. Makes me a little nervous.
I don't recall saying that, so I'm not sure where the paper got it. Well, yeah, a lot of things are in the
okay.
newspaper. Let me clarify. At the recent board meeting, when I gave an item, presented a task force item to the board, I am now working on a summary that the board would like to see first of anticipated changes prior to drafting of the draft ordinance. I will bring that to them at a future date. And I would be happy to bring it to you too. The board asked that it go to them, but I'll make sure that we get it added to an agenda for your input as well.
All right, thank you. And that is it for today. During the meeting today at 12:36.